75 years old.
Yes.
The appellant is enjoying the stay from 2005. It's a very old matter, your lordship. Paper book is filed.
No, regarding what? Claim case or second appeal?
Second appeal, your lordship.
Okay, next month. All hearing matters will be included next month.
Lordship, earlier occasion, your lordship allow the mentioning slip several times, or your lordship.
Question is, you see, all hearing matters will be included in the monthly list of January. Okay, you may give the slip. Yes. Claim case application.
Admission.
Claim case admission. Yes.
Lordship, may I permitted to mention, Lordship, this is a claim case, Lordship, under hearing for inclusion in the list.
For hearing, ready for hearing. Yes, next month.
Sir, একটু
Next month.
Application and appeal.
So regarding application, it will appear, but if it is ready for hearing matter, then next month.
Well, claim case application.
Application.
Hearing month January.
Okay, hearing January.
Well, claim case application.
Yes. Yes. Okay, give the slip.
Paper book we have filed. One of the respondents have filed the paper book.
Okay, to be mentioned tomorrow.
My lord, with your losses mentioning one matter, earlier I mentioned on 11th 4th,
Yes.
November 4th. My lord, this is in connection with second appeal and application.
Yes.
Initially, admission appeal has been admitted with the division bench.
Yes.
There was an interim order. The other side filed a cross examination. Sorry, cross appeal. That is also there. But the learned magistrate court below, my lord, is asking for, my lord, an interim order. Initially, there was interim order, but on the technical ground,
No, interim order is not in existence now.
not in existence.
So that has to be extended.
That is to be. My lord,
When is the next date fixed before the trial court?
next date on November 17th, that was date. On the request, it has been adjourned. My lord, file is here. I have brought the file.
No. When is the date fixed before the trial court?
My lord, execution proceeding on November 17th, that was the date.
Yes. Next
Date, my lord, in the middle of December. My lord, as in let
So let it appear as to be mentioned. Sub notice upon the other side.
Yes. File সেখানে আছে শুধু।
Yes.
File সেখানে আছে।
Claim case application and hearing.
Okay. Application will
File
appear,
taken
but
out.
hearing next month.
4/11 তে mention করা আছে।
Yes.
I am grateful.
Fixing a date.
We mentioned for hearing.
To be fixing a date, madam. Can you see, madam?
No.
22, madam. Second mistake, sir.
Okay. Give the slip. To be mentioned.
My lord, may I be granted your lordship's kind leave to mention the matter for inclusion? It is an application filed in connection with the second appeal, lordship.
Application for?
Stay, lordship.
Yes.
My lord, your lordship was kind enough to dispose of this appeal, my lord, on 26th of November, last week, my lord. My lord, minor clarification is required, my lord. Let it appear
Okay,
as
to be mentioned.
to be mentioned, my lord, on tomorrow, my lord. To be mentioned. Grateful to your lordship.
Number 2.
My lord, I am for the appellant. Sir, it may be fixed for hearing. Paper book has already been supplied. The opposite party.
Yes. Record an order. Learned advocates for the parties are present. As the matter is ready for hearing and the paper books have been filed, let this matter appear on 2/1/2026 under the heading hearing.
Obliged to my lord.
For my lord, I am for the appellant. In this case, my lord, there is a can regarding in relation to My lord, there are 4 appellants. Number 1 is the wife of the deceased. Number 2, 3 became major. So another number, appellant number 3 also got married. The title should be changed. I have filed the A-B Aadhaar card annexure and also C, the change. Another is, my lord, appellant number 4 is found missing since 11/10/13. So for the last 13 years.
No,
Now,
appellant number?
my lord, at annexure D and E, the missing diary of Sagar PS and also the
No, no.
Pradhan certificate.
You obtained power when this appeal
Yes,
was filed.
yes.
This appeal of which year?
Appeal of 24.
24. So when you obtained power, this person was available.
Yes,
This appellant number 4.
4. So it should be expunged and his share should be divided. Sir, I also filed one
Change the name of appellant number?
4.
4.
4.
So no, can we expunge in that way?
No, no. No.
Just because the person is not available, there is no declaration that the person is dead.
Sir, I lost diary. at the
Whatever it is, you
My lord,
see,
I kindly
on what basis the court will declare this person as dead? Maybe he is not available. Just because a person is not available, this court has no power to declare the person as dead.
My lord,
Unless you obtain, is there any order?
my lord, I filed the one decision of the Honorable High Court Division Bench where the Calcutta High Court and no need of necessary of producing death certificate or any correct other certificate. Kindly see. In this case, 7 years, sir. Presumption that he is dead. No necessity for giving death of death. No necessity of giving documentary evidence of death. Fact of death can be proved by circumstantial evidence or oral evidence. Nobody come forward that she is alive.
It is not traceable for more than 7 years.
Yes.
This is not your case. You have filed this appeal in 2024. You have filed this appeal in 2024. So you have obtained power from this person. So he was traceable at that time. So no. When is this appeal filed?
Appeal, no.
2014.
When is this appeal filed?
Appeal file in the year
2014.
2014.
14.
2014.
2014.
Yes, my lord.
So when this appeal was filed, he was available. So from when is he missing?
See.
From when? Where is the diary that he is missing? From which date?
Sir, I have annexure. Kindly see annexure D. D and E annexure, my lord. Before that. He is found missing before that. 11/10/13.
Okay, just obtain another report from the authority. Okay.
He has to go before the district judge's court, my lord. To that, the proper process is, even this judgment, I am thankful to him for giving this judgment to my lord. This judgment is also, it says that he has to go before the concerned district judge to obtain the certificate. In that proceeding, my lord, the death certificate may not be needed.
No,
That is what the finding of this judgment. My lord will kindly come to page number 339, paragraph 23, my lord. This judgment is not applicable in this case. Motor accident claim appeal court doesn't have the jurisdiction to declare a person dead. We therefore hold, paragraph 23, we therefore hold that in an application for grant of succession certificate or probate or letters of administration, There is no necessity of giving the precise date of death of the concerned person, nor is there any requirement of adducing documentary evidence alone in support of such fact, and the same can be proved by oral or even circumstantial evidence. There is even no necessity of filing a separate civil suit for declaration that the missing person is dead before filing an application under the Act, Indian Succession Act. This Act is Indian Succession Act, because it is within the province of the court dealing with the application to give such declaration. The court, while considering an application under the Act, Indian Succession Act, is required to come to the conclusion on the basis of evidence on records whether the missing person was dead on the date of presentation of the application in order to exercise jurisdiction under the Act. I repeat once again, Indian Succession Act.
Okay, record and order.
He has to go before the district judge.
Learned advocate
It will,
for
it will
the
take another 30 years.
But my lord doesn't have the jurisdiction.
appellant is present.
Police, you may direct the police
Learned
authority.
advocate for the appellant and the learned advocate for the opposite respondents. The appellants have contended, appellant number 1, 2, and 3
One day are alive.
contended that the appellant number 4 is dead. Learned advocate draws to the attention to the missing diary lodged in the year 2013. The application, the learned advocate also relies upon decision of this court in the case of Sudarshan Shaw versus Subhash Shaw, reported in 2005 within bracket to CLJ Cal. So this case is of 2014.
No.
2000
Case is 2004.
6.
ये तो
2006.
2006.
2006.
Upon considering the submissions of the learned advocate, this court is of the view that the appellants should be granted liberty to submit further documents as to the present stage of the inquiry by the police authority with regard to the appellant number 4, who is alleged to be missing. Thus, the said report may be collected by the appellants and filed on the next date fixed by a supplementary affidavit.
Well,
One thing-
My lord, how can I collect? Well, I will direct the police officer
No,
to
no,
submit
the-
the report.
The appellants will make the person, it is this person's relations who have filed the missing diary. So they can apply and collect the report
Where from?
from the police authority itself,
All right.
because this order speaks for itself. In the event any application for report is made by the appellants, the same may be provided by the police authority.
Much obliged.
Let this matter appear for further orders on 6/1/2026.
Much obliged.
Grateful, my lord.
My lord, one thing, report may be sent as quick as possible.
Now, I'm keeping it prior to that. You make your application, that will be provided.
Application before the police authority.
Yes, yes, yes.
In this matter, in this appeal, my lord, I am for respondent and cross objectors. There are two can was pending. One is section 5 of the court and 2 is amendment application for spelling mistake. My lord, server showing can 1 is disposed of. So on earlier date, I have submitted before your lordship only can 2. My lord, in this situation, can 2 was amendment application was allowed, but can 1 section 5 is pending. আজকে কোর্টের নাম্বারটা দেন অ্যাপিলের সাথে
You are the appellant.
No,
I'm the applicant.
I am for respondent cross objectors. I have filed court.
So it is your application for amendment.
My lord.
This COT, no, this application can do is your application.
My lord.
And to my lord disposed of.
Can do is disposed of.
Can to dispose of, there are
Let
some,
let can one be put up?
section 5.
Yes.
Yeah.
My lord, this is file ma'am.
কি?
কেন তো ফাইলেই আছে।
Yes. On earlier date, can one is file আছে, আমি সেদিনকে দেখেছি। Can one আছে, section 5 দেখুন। Can to আপনি কি দিলেন?
কোর্টের
on সেদিনই ছিল।
হ্যাঁ কোর্টে কেন
আগের দিনে কোর্টের 1টাই ছিল। এই কোর্টের 1 2 দুটো ছিল। সেকশন 5 দেখুন। আমি সেদিনকে আপনি দেখুন সেকশন 5 ফর লিমিটেশন অ্যাক্ট।
রাখছি, হ্যাঁ।
নিচের দিকে আপনি ডান হাতে বুড়ো আঙুলটা দেখুন।
Can one
Can one
of 2023.
of court.
Yes. $2,619 days.
Yes, my lord.
Okay. Did you file any objection to this application? Yes, record an order. কিন্তু এটা তো রয়েছে।
এটা কমপ্লিট করি, টেকনিক্যাল মিস্টেক। দেখি না কি বলে। Well, paper book was filed.
Yes, treated in the days list. Yes, record an order. Learned advocates for the parties are present. The appeals, the stroke cross objection being court number 48 of 2023 is treated on the days list by consent of the parties. Can 1 of 2023, which is filed for condonation of delay, is taken up for consideration. Stop. Upon perusing the grounds and upon hearing the learned advocates, this court is of the view that as no written objection is filed with regard to this application for condonation of delay, this application in the interest of justice should be allowed. Thus, delay in filing this application being COT 48 of 2023 stands allowed, and COT number 48 of 2023 is admitted.
Much obliged.
My lord,
Paper book is filed, my lord. It is ready for hearing.
As the paper books is already filed.
Already
the
filed.
matter be sent to the local authority.
The paper books in this matter is filed and the matter is ready for hearing. Stop. As there is a chance of settlement in this matter, the matter is sent to the National Lok Adalat to be held in the month of December. Stop. Let this matter appear on 8/1/2026 for report of the Lok Adalat.
Much obliged. Much obliged.
So she item number 6, and she is appealing for this matter, but she underwent tooth extension surgery. So, Lordship, I am paying for one accommodation.
Okay, not this week.
I'm for the cross objector, my lord. I am filing the affidavit of service in respect of court, my lord.
Yes, record an order.
And my lord,
Learned
this matter
advocate
can be,
for the
my lord, LCR may kindly be called, my lord.
learned advocate for the respondent is present. Time is sought for on behalf of learned advocate for the appellant. Stop. As the trial court's records have not come, let the trial court's record be called for and a reminder be sent. Let this matter,
My lord, liberty to obtain the certified copies for preparing the paper.
upon arrival of the trial court records, the paper books may be prepared on obtaining the certified copy.
Deeply obliged.
Let this matter appear on 6/1/2026.
And my lord, I have filed the affidavit of service in respect of the court.
Okay, the affidavit of service file be kept with the record.
Biplab.
Lordship, I beg to
Right.
appear on behalf of the
My
respondent.
lord, I appear for the appellant, my lord. The paper book is ready. May I, it's in 2 volumes, my lord. 2 volumes. I have served volume 1. Let me serve my lord volume.
No.
Very short point involved, my lord. Entitlement or relationship of the deceased, my lord. Or it
Yeah.
may be
Record and
fixed on
order.
paper file and copy served.
Learned advocates for the parties are present. As this appeal is ready for hearing, let it appear on আচ্ছা 3 তারিখে দেখুন তো কোনো ফিক্স ম্যাটার আছে 3 তারিখে
Third is, my lord, 5th is reopening, my lord.
no 3rd of this month. Are you ready to do it in this
Yes,
month?
yes, they're ready.
My lord,
Ready.
this month it will be difficult, my lord, because we have to seek instructions from the department. As the paper book has been, kindly make it in the monthly list of January, my lord.
Let this matter appear on 2/1/2026.
My lord, kindly, my lord, accept 2, my lord.
Yes.
Except after 6th, 6th,
Matter
any
appear on
data.
7/1/2026.
Grateful, my lord. Grateful. In the meantime, my lord, I will seek instructions from the department. Grateful. Number 9, Lordship, I am for the claimant respondent.
I'm for the appellant, my lord. Stay application disposed of, my lord, paper book file.
Paper book file?
কি করেছিস কারণ আমি তো পেপার বুক আছে না হ্যাঁ বলুন
Lordship, the very hot point involved in this issue, that's Lordship, the claim case was filed, Lordship, in the year of 2007, Lordship. So
Paper
kindly
books are filed already.
already filed, matter is ready for hearing. 2007 claim case file. They have paper and appeal. They have some ground. They will place.
Yes, are you ready to settle?
No,
Your
we
client
cannot.
is ready.
no because my lord, the grounds taken in this appeal that check issued for premium that was dishonored. That is one of the ground, and second
Okay,
ground, my
record
lord,
an order.
So can you fix
Learned
any?
advocates for the parties are present, heard learned advocates. As the matter is ready for hearing, let it appear on 5/1/2026.
Lordship, not this year.
No, this year there are several matters. 5/1/2026.
For hearing, Lordship.
Yes.
Yeah. 5/1.
And my lord, I'm appearing on behalf of the appellant insurance company, my lord. Paper books are ready.
Lord, I am for the respondent, my lord, claimant respondent. On
Hmm.
Friday, my lord, it was fixed for hearing at 2 p.m. When the matter was taken up, my lord.
I think another matter is fixed at 12 p.m. today. Is it your matter?
No. It was, this matter was fixed on Friday at 2 p.m.
Maybe, my lord, it was, but
So-
Lord will fix it up for hearing any day.
Yes, I'll fix it up tomorrow itself.
My lord.
Not
Yes.
tomorrow and day after, I have some personal difficulty. I may come, I may not come. Maybe sometime next week, my lord.
No, my lord, by this week. Kindly take up.
My lord, kindly make it by this week. I'm for the respondent number 2.
Then they'll complete their submissions because it's my appeal. I may be having personal difficulty. That is next week, my lord will fix it up kindly. Any day next week.
Keeping it on Thursday. What is the
Yes,
Thursday?
Thursday would be
prayer.
great, my lord.
On her prayer, my lord, the matter was fixed on my last Friday.
Yes, my lord.
On
No,
her
no.
prayer.
You see, Thursday you have any difficulty?
There is a personal difficulty. Tomorrow, day after, I know that I have some difficulty, but about
lord,
Thursday,
keep
I'm
it
not
on
very
Thursday.
sure. That is why I'm saying that.
Friday?
Very fine.
Yes, record an order.
On Friday, within 12.
Yes, at the very first.
Because my lord has the original side also.
Learned advocates for the parties are present. Heard learned advocates. As the matter is ready for hearing, let this matter appear on 5/12/2025 at 5/12/2025. At 10:30 a.m. top of the list.
Grateful,
I'm
my lord.
grateful, my lord.
5/12/2025 December.
Eleven, 11, I'm for the appellant, my lord. Last occasion, my lord, stay application disposed of, my lord, entire awarded sum is being deposited before this honorable court, my lord. Last occasion, my lord, on 3rd November 2025, your lordship directed me to put notice of appeal and Talavana in the concerned department to serve upon the that my lord, on 10th November 2025, my lord, I have took steps, my lord. Let the department serve notice upon the for the time being, let the matter go out of please.
Yes, record and order. Learned advocate for the appellant is present. As the appellant has caused service of notice of appeal, taken steps to cause service of notice of this appeal, but the said service is not complete. Let this matter appear on 12
On my lord,
12/1
very good.
12/1/2026.
My lord, I appear on behalf of the appellant, my lord. I'm sorry, I am appearing virtually, my lord. It's my appeal. In this matter, Mr. Rai has already filed the paper book, but I am not aware whether the lower court record has arrived or not. But this appeal cannot be heard without the lower court record, my lord. I will be insisting your lordship to let the lower court record be called here, my lord.
Yes, record and order.
Lordship, may I?
Yes.
Very well, his submission can be considered. Prior to that, Lordship, I have obtained the certified copy and in the
But
certified.
I am not concerned with his certified copy. Let the lower court record be called.
Lordship, there is the opportunity submission. I have served, I have prepared the.
Mr. Rai should not comment what is unfortunate and what is fortunate. But this should not continue, my lord. It's
Yes,
my
but-
appeal. I am praying for local record to be called for.
Yes.
Call for, that is their submission can be allowed. I am not saying anything against the submission.
Yes.
He is saying, he should have said that physically he should appear before the court of law. He
Yes,
accepted the
record.
paper book
Yes, record and order. Learned advocate for
without
the
any objection.
parties are present. The paper books have already filed, but the trial court's record. Okay, the paper books are being filed today. Let it be kept with the record as the trial court's records have not come. Let the
The record is already in the.
okay, the trial court's records have come.
Without any instruction is submission
Yes,
is that.
let the trial court's records have come.
Already on record.
As this is a motor accident claims matter and it may be settled, the matter is referred to the National Law.
No, it cannot be. It is their appeal. My appeal also kindly.
No. You see, I'll not be able to take up hearing matters in this month. Okay.
Not done.
So very well. After Lok Adalat, if it is settled, well and good, I'll take up the matter.
That means, Lordship, I have also a separate appeal. The appeal number 1 of 2025. That is not with the appeal. Can it tag with the appeal?
Whatever it is, it will be tagged and sent. Let the
You will send. I have not talked with. I don't know whether Mr.
in the meantime, you take instructions. This matter be sent to the National Lok Adalat to be held in the month of December. Let cross objection COT.
Not it is a fresh appeal.
Let FMA
FMAT
212 of 2025.
I have not been served with a copy of the memorandum of the appeal.
That has been sub
Be also tagged with this record
without
and sent to the Lok Adalat. Learned advocates are requested to take necessary instructions with regard to the settlement before Lok Adalat. Let this matter appear on 7/1/2026 for report of the Lok Adalat.
Deeply obliged.
So the record has come. Copy of the paper book, copy of the fresh appeal that has been served. But in
only that other appeal has to be tagged.
That has been
Record has called, but it has not been inspected. What is he saying? No notice has been given from the department about the inspection of the report. The lower court record.
Comprehensive appeal has been filed.
Appellate side rule says that a record has to be inspected by the department and found complete. Then the appeal can be heard out. What Mr. Rai is saying.
Now the question is, you take inspection, you ask your client whether they are willing to settle or not.
But that is different. Well, kindly let the department be directed to make the report that whether the record has been found complete or not.
All necessary steps will be taken. But in the meantime, you see, if
I shall deeply oblige, my lord.
Yes, Lordship. The submission absolutely beyond the record. Absolutely. Under the hearing thereafter, after Lok Adalat.
yes, for report of the Lok Adalat, and thereafter it will be taken for hearing if it is not settled. Yes, the other appeal will be tagged with this appeal.
My lord, kindly cut 2 minutes pass over. He is just coming. 31 and 15.
Pass over. Yes. Yes, pass over. Not today.
18. But item 16, I was for that.
The paper book is not here. I'm just making it not today.
Lordship.
Not today.
19, I am appearing on behalf of the petitioner, my lord.
So is it for extension of interim order?
No, my lord.
So how is Justice Sharma's determination?
This is a quashing application under
So let me see the order, last order.
last order, my lord. During the vacation bench, my lord, your lordship
Let me
was
see, let
pleased
me
to take up the matter, and my lord, your
Just
lordship,
a minute.
the order was fast.
Okay. Some extension is required because time to submit the report is over. Yes, record an order. Learned advocate for the petitioner is present by order dated 9/10/2025. The matter was referred to mediation. Stop. And the last date fixed was 25/11/2025.
May I
As
submit one?
just a minute, as the date for submission of the report has passed, the time to submit the report stands extended till 6/1/2026. It is clarified that the learned mediator may fix the venue of the mediation proceedings. Yes, so I've just extended the date.
Actually, my lord,
Yes.
on that day, I thought it was a matrimonial dispute matter. That is why I referred to the mediation, but it is actually.
No, you said that it can be settled.
Well, business transaction.
Yes, civil matter, civil dispute.
Absolutely civil matter. The allegation of the de facto complaint is the petitioner has, my lord, supplied a low quality kazu.
So it can be settled, civil matter. Huh? Huh? No. ওটা বলে দিয়েছি, the mediator shall fix the venue of the mediation.
And my lord, in the meantime, there is an order not to take any coercive steps against the petitioner that may be extended.
The earlier order passed remains untouched, unaltered. Other contents of the order remain unaltered.
Grateful, my lord.
Unaltered.
Your Lordship, and this is my appeal, Your Lordship. In this case, Your Lordship, the pleadings are complete. Your Lordship, the paper book has been exchanged. Your Lordship, now it could be heard at any point of time. Your Lordship,
Last occasion matter appear, I filed on behalf of the respondent, I filed the paper book, and your Lordship was pleased to direct that that the matter would be heard on 24th. Another Friday, I mentioned, your Lordship desired that it be appear as to be mentioned. Any day, my lord, at fixed time, my lord.
See, I'll be taking up hearing matters from the month of January. So the matters which may be settled, I'm sending to Lok Adalat.
Not my lord, not
Not
ten days.
Otherwise, no. You see,
My lord,
if it is not settled, I'll take it up in the month of January. This month, I'll not be in a position to
your
take up any
Lordship
matters.
takes the matter in the month of January, but my lord, don't.
Yes,
take the
is
matter.
your client ready and willing to settle?
no, Your Lordship. No, Your Lordship. This is not as, because we have preferred the appeal, Lordship. If it's a respondent appeal, in most cases, we settle it because it's a quantum.
No, you see, still there is a chance, there may be chance of
Your
settlement.
Lordship, there are some, the appeal is not only in the point of quantum, Your Lordship. In this case, the appeal is also in the ground of non-involvement. So, Your Lordship, it couldn't be settled and it has to be decided by Your Lordship only.
Yes, record and order. Learned advocates for the parties are present. As this matter is ready for hearing, let it appear on 6/1/2026. Under the heading hearing.
মেমো আপিল 28 থেকে 32।
Your Lordship, this is my appeal. In
My
this-
lord,
In this case, we have filed the paper book on last occasion. This is also a matter ready for hearing, Your Lordship.
Is it only on the ground of quantum or other grounds?
my lord, only pay and recover.
Pay and recovery, because if DL was not valid at the point,
Yes, record
My
and
lord,
order.
I take this matter at 2
Let it be
p.m.
on the same day, 6/1.
No, my lord, 2 p.m. your lordship may dispose of.
No.
Regarding quantum, my lord, they have no grievance. Only the driver did not have a driving
No,
license.
have you received the awarded sum? Or
No, my lord, this is appeal by lord, the insurance company. Insurance company had deposited the entire
hearing
award.
matters, I am not taking.
Hearing, no, my lord, it will not be taken up more than 5 minutes.
No,
or
for you it is 5 minutes, for him it may take some time more. You see, we cannot predict.
My lord, your lordship kindly fix the matter on tomorrow.
No, I'm keeping it on 6th in the month of January.
Yes,
Same
My lord,
order on the same.
my lord,
I'm keeping your matter will be given priority.
kindly give my lord the time fix, my lord, kindly.
No.
2 p.m. 2 p.m.
Okay.
2 p.m.
2 p.m. on 6.
6/1/2026 at 12 p.m.
Yes, deeply obliged, Your Lordship. Deeply obliged.
Item number 22.
For the opposite party, it's not as last
My
Friday.
lord, in this matter,
But my lord, same my lord, petitioner my lord paid for accommodation, my lord. I have no objection, my
So
lord.
you are for?
I am for the opposite party. I am suffering, my lord, or order of stay, my lord. The matter is against the refusal of ad interim order. Ad interim order, ex parte stage. So, my lord, being aggrieved, my lord, he preferred title appeal. Aggrieved this revision application. My lord, without going into merits of the case, my lord, kindly visualize that an injunction application.
What are these applications for? Can 1, can 2?
Can on, can do.
my lord, matter can be fixed at 2
Soft
p.m.
copy of this application.
My lord, my lord,
Copy has been served.
every day,
No.
when the matter will be called.
Soft copy of this application.
They-
This-
Already served, my lord. Applications have been served.
Copy service, copy served, no, my lord. No copy has been served, my lord.
What is this? What are these applications?
These are the applications
Extension,
for the extension.
Instead of going into the matter for hearing.
My lord, may it be taken up at 2 p.m. my lord.
Kindly consider these aspects. The main revision application is against the refusal of ad interim order by the trial court as well as, my lord, appellate court. So, my lord, ultimately, injunction application is pending before the trial court. So, injunction application will be disposed of by the trial court itself. So, my lord,
The question is further proceedings are not stayed. Only he is enjoying an interim order.
my lord, for that reason, he is taking time in the court below. 6 December is
No, interim order, you see, you are enjoying an interim order. So let the interim order be there, but don't pray for any adjournment before the trial court.
We are not preferring any adjournment before the court below, man.
My lord, kindly
My lord,
pass
when
one line order that pending application.
When this interim order is going to expire?
Well, already expired.
Yet, we have filed the application before expiration of the interim
Yes,
order.
record an order.
It can't be, my lord.
Learned advocates for the parties are present.
Well,
This-
we are suffering, my lord.
This matter,
Let the trial court be heard out the injunction application on merit.
although this matter is ready for hearing, but it was not taken up on the ground of adjournment sought for by the petitioner. Stop. As the matter pending before the trial court is also not proceeded with due to pendency of this matter, it is hereby clarified that the trial court may proceed with the suit. Stop. However, the interim order passed by this court stands extended till 9/1/2026 or till further orders, whichever is earlier. Let this matter appear on 6/1/2026. So you proceed with
My
the
lord-
suit, but this interim order will continue.
Time may be fixed.
My lord, this is fixed
Date and
for
time,
hearing injunction application.
No. The suit
Trial-
can proceed with. If there are other interlocutory
No,
applications,
no, only injunction application.
anyway, whatever it is,
Or specify that
but
trial court may
they proceed with the suit. I have just made it.
Even-
You
even
get a wide
order-
opportunity. But
Order
this
39
interim
rule
order
7
will
is still
continue.
pending, my lord. Order 39 rule 7 is still pending, my lord.
Very well, you proceed with that.
Will proceed.
My lord,
But this order will continue.
my lord, without disposing of injunction application, how he claim
Then you come
order
ready.
37.
Anyway, when is the next date fixed before the trial court? 6th of
December.
So,
Anyway, just wait. I fixed it in the month of 6th of January. You come on that day. I shall take it up.
6th of
January.
January. My,
Kindly send the matter to the local authorities.
Yes.
Send the matter to the local authorities.
Yes, record an order. Learned advocate for the appellant is present. As this matter is ready for hearing and the paper books are already been filed, the matter may be fixed for hearing. Stop. However, as this is a motor accident claims matter and there is a chance of settlement, the matter is sent to the National Lok Adalat to be held in the month of December. Fix 12/1/2026 for report of the Lok Adalat.
Department directed to send the matter to the local authorities.
Yes, yes. All will be done by the department.
Lordship,
My lord, I appear for the.
For the respondent, your lordship, the Can 1 of 2024 has not been served, your lordship. Can 1.
What is this application? Can one?
Can 1 has been served, my lord. This is. Can 1 has already been served, my lord. This is the affidavit of service, my lord.
What is this Can one?
Can 1 is for section 5, my lord. Let me check.
Perhaps, your lordship, there is a 4 years of delay. In that event, your lordship.
Okay, you serve him. I'll take it up tomorrow.
Not today.
Okay, not today.
Twenty-five, my lord. My lord, this has been served, my lord. But I missed out the affidavit of service. I want to fresh.
The side is not here.
No, I want to solve afresh. Kindly take it on next week and
Yes,
record. Kindly.
I'm just making it not this week.
Making it not this week.
Yes.
Making it not this week. Deeply.
26. 26 is insurance appeal.
Application.
It's appearing for the first time. I was praying for entry mistake, Your Lordship. I have made this statutory deposit. May I
রেকর্ডটা দিন। Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 25th day of June 2025, passed by learned Judge Special Court, Durgapur, Paschim Bardhaman, in MSC case number 57 of 2017 for a period of 5 weeks. The appellant shall take steps to deposit the entire awarded sum along with interest as directed in the said award within the period of 5 weeks. Stop. In the event such deposit is made, the ad interim order of stay shall continue till the disposal of this application. Liberty to mention.
My lord will kindly direct my lord's officer to put it in a fixed deposit.
The Registrar General is requested to invest the deposit made in a fixed deposit of a nationalized bank and to renew the same from time to time.
Obliged to my lord. I'm grateful.
Seven. 27, I am appearing on behalf of the appellant insurance company. This is the statutory copy of the statutory deposit, my lord. It's coming up for the first time. I am praying for stay, my lord.
Yes, record an order. Record to the learned advocates for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 30th June 2025, passed by the learned additional district judge, second court, Asansol, Paschim Bardhaman, in MSC case number 15 of 2016 for a period of 5 weeks from date. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed in the said award within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General is requested to deposit the invest the sum in a fixed deposit of a nationalized bank and renew it from time to time. Liberty to mention.
I shall also serve upon all the respondents.
Yes, that you serve. Thereafter, either you serve personally, thereafter, if they don't appear, you have to serve through the department.
My lord, the application or the memorandum of appeal?
No, both application and memo.
My lord will add one line, my lord, for my.
Yeah.
Will direct me to serve.
The appellant shall take steps to cause service of the notice of this application as well as the memo of appeal.
My lord.
Upon the respondents.
Grateful, my lord.
Twenty-eight.
28, I am appearing on behalf of the appellant insurance company, my lord. In this matter also, I have served. I have deposited the statutory amount.
Yes.
I'm praying for similar orders as in the last matter.
Yes, learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 28th day of August 2025, passed by the learned additional district judge, First Court Alipur, South 24 Parganas, in MSc case number 53 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed in the award within this period of 5 weeks. Stop.
Less statutory deposit.
Yes, excluding the statutory deposit. ওই আগেরটা তো করে দেবেন, excluding. In the event the deposit is made within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The appellant shall take steps to cause service of notice upon the respondents. Liberty to mention.
My lord. And the investment of grateful, my lord.
Hmm? 12 p.m. Yes, 12 p.m. fixed matter.
Your lordship will be taking up apposite matters up to 12 p.m. because that is.
No, I'll take the fixed matter now.
This indication is apposite up to 12. Okay, but the full.
My lord, item 20 and 21.
Yes.
20, my lord, your lordship, my lord, I finished my argument. My lord, kindly remember.
Okay, who is appearing?
My lord, she has started.
So
and
the
my
argument was complete.
I finished my arguments. My lord,
His submission, my lord.
boleni.
Did you submit that list of dates and compilation?
Yes. I have submitted, my lord. এটা একটু দিয়ে দেবেন একটু জাস্ট বলো পরেরটা শুন
That copy has not been given.
এই আমি তোমায় কপি দিয়েছি তোমাকে বললাম আমি বাড়িতে গিয়ে পড়ি এই তো লিস্ট অফ ডেটস না সাইটেশনের যেটা I've already handed over, the judgment which.
Yes, you have argued. Both of you have argued this matter.
My lord, kindly remember.
Judgments, and if you want.
Kindly remember, he was a, my lord, ITI student and also, my lord, doing part-time job earning rupees 5,200. My lord, in one motor accident, both the, my lord, brothers, in one family, both sons. My lord, the claimants, appellants are the, my lord, the parents. They are claiming compensation, my lord, 30 lakhs and 20 lakhs in both the cases. One, my lord, son is, my lord, is 18 about 24 years. He has completed his, my lord, studies, and after that, my lord, he was doing, my lord, the ITI.
So two separate appeals.
Separate appeal.
Separate appeals.
My lord,
Let it submit separately.
Yes, separately.
No, your appeal is this 38. FMAT 38 is your appeal.
No.
No. Oh, FMAT 38, right.
Yes, both the appeals
by the claimants' parents.
By the claimants. For the, my lord, only with regard to, my lord, income of the, my lord, the victim disease. My lord, first appeal, your lordship, kindly see. Yes, first appeal is FMAT 38 of 2023.
Yes.
হ্যাঁ দাও চুপ করছো
এই FMAT 38 টা দিন। Yes. What are the grounds of this appeal?
My lord, the grounds of appeal here. Kindly grounds of the appeal with regard to, my lord, the income. My lord, this is, my lord, was a student of, my lord, CBSE, my lord, schools, my lord, going to appear Madhyamik examination. 10 years, my lord. He was aged about 16 years old. My lord, accident took place 2015.
Just a minute. That is Yes. No, what is the ground of challenge in this?
Is ground of challenge, my lord, regarding the income. Income learned tribunal assesses only 5,000. But my lord, I am relying, my lord, on some decision of the Honorable Apex Court, where my lord, the incomes with documents were not available. What would be the guiding factors? My lord, the Honorable Supreme Court, in case of a minor, my lord, Kajol versus Jagdish, and my lord, the Ayush, and আরে বাবা দিয়েছি তো এটা এটা 188 দেখছো কেন?
No, no. What
Malad,
judgment? Yes.
দাঁড়া চুপ কর তুই ঝটপট করবি না। এই যে এতে কি 38 অঙ্ক আছে। First, Malad, your lordship kindly see the Apex Court judgments. Kumari Lokshmiyari versus Managing Director, Karnataka State Road Transport Corporation, decided on 5th March 2000, this year, 2000, where the victim minor girl was aged about 12 years old. My case is, my lord, he was 16 years old. Accident took place 2013. Apex Court took monthly income of the victim as rupees 10,000. This judgment was, my lord, Kumari Lokshmiyari versus Managing Director, KSR Corporation. My lord, page 1 to 6. Then, my lord, your lordship kindly see, my lord, page 1 to 6. My lord, where your lordship kindly turn to page 4 of my lord citation.
Page 4.
My lord, calculation of compensation.
No, just this decision which you are relying is Kumari Lakshmi Sri, which page?
Which page, my lord? Page 1 to 6.
Yes, which paragraph?
Paragraph is, my lord, 15. Page 4.
Yes.
My lord, where the Supreme Court, my lord, has, my lord, assessed the monthly income 10,000. As per the Ayush versus the branch manager, so and so. So yearly income comes 1,20,000. My lord, calculating that portion, my lord, the figure comes, my lord, is 99,52,420. My lord, I am only confining.
What was the occupation of this victim in this case?
He was a minor girl student.
Student.
My case is also a student. He was a student of a CBSE school going to appear Madhyamik. Accident took place, my lord, in the month of, my lord, December. That is last 30th December 2015. Accident took place. Here, my lord, the Lokshmiyari accident took place in the year 2013. At that time, my lord, the Honorable Apex Court, my lord, thought it that what would be the, my lord, the income of a minor girl who was a student, my lord, considered 10,000 following the decision of Ayush. My lord, your lordship, then, my lord, your lordship kindly turn to the second judgment. This is also, my lord, the Supreme Court judgment. Page 7 to 30. It was decided also this year, that is 8th August 2025, where the accident took place, my lord, 2012. My lord, here the claimant was 8 years old at the relevant time. He was a student. Apex code took monthly
Page.
page,
That is
my lord,
Hitesh Nagi bhai.
page 7 to 13. Apex code took monthly income at rupees 6,836 as per minimum wages act. Relied on, my lord, the Kajol versus Jagdish and Baby Shakti and Gedila versus Manjur Ahmed Singh and another. This is also reported in.
This is disability.
It's an injury case. I am only confined to the what the Supreme Court follow a minor whose income is my lord as per the minimum wages act. Why the my lord documents are not available. Your lordship kindly appreciate in many cases. Rickshokula, my lord a coconut climber, my lord a fish seller. My lord, they are not able to furnish the documentary evidence in support of their, even if students. What would be the students, my lord says? My lord, your lordship kindly see, my lord, Supreme Court, my lord, time and again says that the just compensations, my lord, be given as per section 168 of the Motor Vehicle Act. My lord, in this case, Learned Tribunal awarded only 7,56,000. Kindly think over. If it is, my lord, fixed in a bank deposits, 7,56,000. My lord, income would be, my lord, how much? My lord, 6%, 7%. At the, my lord, at present bank rate, it comes, my lord, below 4,000 or 3,500 per month. If it is fixed, kindly think over, man. If it is fixed, man, the parents, they have the only two sons, and two sons died in a motor accident. They are passing their rest of the life, without sons. Kindly think over, here the tribunal has arbitrarily assessed 5,000, while the Supreme Court says in 2014 a student income may be assessed 10,000, and second judgment I am denying that the 6,836 as per the Minimum Wages Act, that was accident took place 2012. Now, my lord, here the second judgment relied on Kajol versus Jagdish and Baby Shakti. That was also, my lord, I have in my compilation judgment, I have added. My lord, page 19 to 30. Kajol versus Jagdish.
Yes.
My lord, kindly turn to page 19 to 30.
Yes. Which paragraph?
Paragraph is, my lord, yes, my lord, paragraph 27, page 27. Page 27.
Yes.
My lord, may I permitted to read paragraph 27, but for a moment. On factors which must be kept in mind while assessing the compensation case like the present one is that the claim can be awarded only one. Only one. The claimant cannot come back to the court for evaluation of the award at a later stage, saying that something extra has been paid. Therefore, the court of the tribunal has to be completely in favor of 100%, especially where there is a mental disability. While awarding this amount, we are not only taking the physical injury but also the mental disability of the child will remain bedridden for life. Her mental against one so the girl will miss out paying his three friends. My lord. Yeah, yes, Ballard, your lordship, kindly turn to page 29. This is a computation. Loss of earnings, family members, 51,000. If it is Ballard divided by 12, it would become Ballard more than Ballard the 400 something. Here, the accident took place, Ballard Kajol versus Jagdish. Accident took place, Ballard 2007. Though Ballard, it is a Ballard injury case, but Ballard like 100% really like it, Ballard death case. Other days I am not Ballard arguing. I am arguing only point of Ballard, the income of a minor, the minor income of a student. Ballard, here the tribunal has arbitrarily assessed 5,000. Ballard, as per the minimum wages, if your lordship sees Ballard on the relevant time,
দিয়েছো দেখো দাগ দেওয়ার
কোনটা দেখি আমার দাগ করাটা।
এটা আমার 4 না 5 নম্বর পাতা ওইটা দাও
এটা একটু this is also minimum wages notification. The period is 30th September 2015. Malad, in my case, the accident took place, Malad, 30th December 2015. Generally, 6 months, Malad, after Malad, the pay or fixations be divided.
No, this is where regarding agriculture. For workers employed in agriculture.
It is Malad, your lordship kindly turn to page 4.
Page 3টাকে দেখিয়ে নাও তারপরে page 3টাকে দেখি
Yes.
Page 3, Malad, is a Malad, the page 3, Malad, in the bottom, unskilled, semi-skilled, skilled, clerical, that is VDA, Malad, that is dearness allowance. Malad, next column is page 4. The skill or clerical persons, that is for work above, that is 353. And for work below ground, it is above ground. He was a CBSE student, kindly think, one day, he may work something. That is, that the Supreme Court time and again, where the students, income as per the minimum wages. I am stressing upon the minimum wages at the relevant time, where the skilled person, Supreme Court says Kajol versus Jagdish, the student income may be assessed as per the minimum wages. Kajol versus Jagdish and Ayush and here page 4 says, supposing 353 per day, 353 per day income should be 10,000 in a month.
এই দেখাচ্ছে মেনটা দিতে
No, what was the nature of the work the victim was do, you see?
Here
Technical, some technical type of work.
My lord, here, my lord, on the assumption, presumptions, my submission is, my lord, he was a, my lord, good family, educated family, and my lord, he was a student of a CBSE schools. My lord, if my lord students who is studying my lord in a CBSE school, at least kindly think over my lord, my lord, the monthly, my lord, the school fees or the yearly school fees, not that my lord, 8,000 or 10,000 earnings, my lord. My lord, his next case is elder brother. He is also, my lord, earning, my lord.
No, what was the age of this person?
He is 16 years.
16 years.
Learned tribunal, my lord.
And nature of work done by him was?
Student.
Student.
My lord, he had, I have no grievance about the application of multiplier.
Emotional income, you see, we have to follow the decisions. But so far, it is an admitted position. He was engaged in some work.
If you lordship.
No, notional income where income could not be proved.
Your income
Okay.
could not.
Student and where there are no evidence with regard to income or work.
In Lakshmi Valley,
Yes, but where there is some evidence that he was working in an establishment,
no.
then that minimum wages comes into.
My lord, then my lord, your lordship kindly consider Kajol versus Jagdish and Ives. In this case, my lord, both of the, my lord, the victim was a student, and Lakshmi Valley case, which I am relying, he is also a student. My lord, where the Supreme Court, my lord, in 2025, my lord, assessed the income of a, my lord, minor girl students, my lord, as 10,000. Kindly, but the learned tribunal, without any, my lord, guidelines, minimum wages, or the Supreme Court has arbitrarily assessed, my lord, 5,000. Kindly think over, my lord, only some presumption, assumptions, or some guesswork. My lord, the compensation may be granted. My lord, the Pronoysheti case, my lord, has not discussed the income. Income is discussed by other various judgments of the Honorable Apex Courts, which I am relying. My lord, a CBSE student who is aged about 16 years, he is going to appear on Madhyamik examination after 2 or 3 months. Accident took place 18 December 2008, 30th December 2015. Madhyamik would be held on March. A CBSE student.
One of the sons did not engage
Well,
himself in
there
any
is
work.
some materials in my paper book
No.
that he was
Question
a
is,
student.
one of the son was not engaged. Another son was engaged in some work.
Yes.
Younger son was not engaged. The elder son was engaged.
Engaged. Yes. In a one family.
With regard to that engagement in that particular establishment, you see, if the income is proved, then the court has to proceed on the basis of that income.
Yes, but where the income has not been proved,
so in the case,
minimum wages would be guided.
Yes. Now the question is, if there is any specific circular with regard to minimum wages, that has to be followed. But the question here is this: with regard to one of the parties, one of the victim, the income was proved probably.
Income was proved. Malar is a part-time job, but he was a student of a Malar ITI, not IIT, and Malar is a first year Malar. That is 2015.
See, there are two ways. You see, where student not engaged in any work, student engaged in any work.
Yes. Your lordship.
Student has not engaged in any work, the Supreme Court decision can be followed. But
Yes.
where the student has engaged in work, which is proved,
Yes.
then this court to some extent has to follow that.
Yes, that I'm grateful. In this first case, he was a student. He was not engaged in any work. He was due to appear in Madhyamik examination class 16, aged about 16. Multiplied the tribunal applied. I have no dispute. Future prospect 40% give it. I have no dispute. Even if parental consideration granted in this case, that was not disputed. The the loss of estate and the funeral expenses granted, not disputes. I'm only disputing the 5,000 Malad, a CBSE student can be only income. 5,000.
In both the
is
cases,
proper.
5,000 was taken into
No, no.
consideration.
Malad, in second cases, was engaged Malad in a part-time Malad job, earning rupees 5,000 something, and also doing ITI student in the same Malad in the year 15 to 17. Malad, his income has been assessed by the tribunal 6,000. I prayed, my lord, following the decision of our High Court, Ranjana Molik, that I have, my lord, placed, my lord, in another day list of citations where the Ranjana Molik and also others, my lord, where the boy who was aged about 20 years, 21 years, 24 years, income should be taken as 20,000, income would be taken as a notionally 15,000 years. That, my lord, I will consider, my lord.
Anyway, so far these cases concerned, the decision relied upon by you can be considered.
Can be, your lordship, I leave it to your lordship. My lord, the assessment which I have assessed on the basis of 10,000, that is Lakshmi Rani.
So here you see, with regard to the victim who was engaged, the income is assessed at 6,000, and the one who is not engaged, his income is assessed at 5,000.
I pay, my lord, the 10,000 as Lakshmi Rani's case. That was
The student was assessed as 5,000 and the
Who did not? Both are students. One did not engage himself in any work, the other engaged himself in
minor and another is major.
major.
Minor.
That means one of the students did not engage himself, simply a student.
Yes.
The other was engaged.
না আমি বলি যশার যা জিজ্ঞেস করছে
So it is not that one is engaged, the other is not engaged.
Malad, here is first case I have taken in my assessment as 10,000 following the Malad Malad Lakshmi Rani's case, and also Kajal versus Jagdish and versus Ayush and others judgment of the Honorable Apex Court, where the income has been assessed more than Malad 8,000. Your Lordship, kindly have a look, Malad. Kajal versus Jagdish, that your lordship kindly read. That was, and Kajal versus Jagdish, I have, and another one, two judgments I have given in my compilations. That is Reliance General Insurance Company versus Sushil and Sochin, where the accident, my lord, kindly. But the accident took place 2030 Supreme Court considered the monthly income of the victim injured who was aged about 17 years. My case is 16 years at rupees 5,860 per month. Where accident took place 2013. My case is accident took place 2015, almost 16. End of the December 2015. Kindly consider, whether 5,000 is a just and proper, and it would be just compensation. Kindly consider this judgment. And baby Shakhi, that was also relied on the
So according to you, 6,000 is not the
5,000. 5,000 is not the proper.
And with regard to the other one, 6,000?
6,000 would be, 12,000 as per our High Court decisions. That was given by the Honorable Justice Shumendu Samanto, where we considered the many Supreme Court judgments, where though the student was IIT students, but my case is at that time, I argued that he was an ITI student. ITI students in a in a particular batch, fitter. Kindly remember, fitter batch maybe may have earning rupees 12,000. Your lordship, kindly see.
Yes, which is the other case? You have cited these judge decisions of
that is next page. Next paper book.
No, you have already cited. Probably the hearing is concluded.
হ্যাঁ 188 ওইখানে compilation আছে।
No, this hearing of this case is concluded.
Yes. My part is complete. I am relying on the judgments.
My reply.
দিয়ে আমাকে দুটো দে। ওটা আমাকে দে না একটুখানি। Where I am relying, my lord, the decision of Joshua where 20,000 assets is a death case. And my lord, the Mina Parwara, where the accident took place 2012, where the income was 10,000 assets. He was a student of a Bachelor of Engineer. And Mala 3 is by Oriental Insurance Company Dev Patadi, where income was Supreme Court taken, decided on 2009, 18,000. And next case is Reliance versus Ramjan Malik, that was given by our High Court, the Honorable Justice Shubhendu Samanto, where the income was assessed as 12 years. The victim was IIT student. But here, I confess that he was not a IIT student because record says he was a ITI student. And Delhi High Court relying also the Honorable Justice Shubhendu Samanto, that was given, this was notional income 25,000 in a Maladi BTech in Delhi Malad College. It's a technical, also ITI student is a technical work. He was a fitter. Kindly consider, but the learned tribunal without considering arbitrary assets 6,000. At least 10 to 12,000. In student, kindly consider 10,000 as per the minimum wages. Why I have today I have handed over the compilation of judgment. And last day, when I am arguing the second case, I am handed over the judgment of FMA 188, where I am relying 7 judgments of the both Honorable Supreme Court and our High Court and Delhi High Court. This is why, and there is the paper books contains the materials. The students the mark sheet, admit card, admittedly, learned tribunals has taken. He was a student of a CBSE class 10 and going to appear Madhyamik examinations. And second case, learned tribunal has admittedly taken that he was a earning from part-time job and also a student of ITI. Kindly consider, I pray before your lordship that the income of a the working person part-time job and also ITI student at least 12,000 per month on the basis of the sum judgments and on the basis of the judgments which I am handing over, that's 10,000. That was Lakshmi Rani and also other cases. These are sub and substance of my argument. But the income are not available, the minimum wages, Kajol versus Jagdish.
See, if the income is not proved, okay, then
minimum
then if it is available from the schedule of minimum wages,
yes,
it can be proved.
Yes,
that can be considered.
Yeah,
Yes.
I am handing over
Suppose the nature of the work. Suppose the nature of the work where the schedule of the minimum wages is not available, then notional income.
Notional income.
You see, notional income, it may be 5,000, 6,000, varies. Where the nature of the occupation is not proved.
4 of my notifications, compilation.
No, question is, you see,
not a skill person, particularly field it was not cases. Page 4's case only deals with a skill person, where the income assessed. So your lordship kindly once again page 4 of my notification, which I page 4. Minimum wages minimum rates of wage showing the basic rates of variable BLS with effect from 1/10/2015. Had the accident took place to December 30th December 2015. By the column number skill clerical person is 353. If it is multiplied by 30, it comes 10,000. More than 10,000. That's why I'm paying 10,000 of a student. On the basis of this, the notification.
Where minimum wages rate, particular establishment, mine, factories.
No, minimum. I'm not saying. I'm only.
This for industrial workers. I believe industrial workers.
No, here is also a skilled person.
No, from this category, they
Yes, kindly on presumption that he may be joined in a particular skill, a farm which.
Suppose it is an office or shop.
Office or shop.
So from where do you get that? So anyway, suppose it is office and shop. He was working in some, anyway, that is some. It was not an organized
work or presumption assumptions.
Where the minimum wages list is available for a particular mine, factory, establishment, that has to be followed.
In Kajol versus Jagdish and and also Ayush, where the victim was a student, there is no iota of a particular they field that is in a labor, that is in a shop, that is in a lead machine factory industry. The Supreme Court says that at the relevant time, the notification of minimum wages may be followed. It's a guiding factor.
That I shall see.
Yes, Your Lordship kindly consider.
Minimum wages with regard to what? There are so many minimum wages.
Minimum wages of a skilled person. Of a skilled person. He was not a. Kindly consider. Apart from this, these cases. In Lakshmi Devi Tabbar, the Supreme Court, where the accident took place, in the year 2004, and the judgment was delivered in 2008. Supreme Court says that a unskilled laborer, at that time, might have the earning of rupees 100 per day in 2004. That's why, here, if it is calculated, in 2015, a skilled person, he may be skilled or unskilled. Wages cannot be, in Sulekha Mondal, that was also decided our High Court, that in the year 2012, the Honorable Division Bench consisting of their Lordship, the Honorable Justice Horish Tandon and the Honorable Justice Vinod Mahachar says, in 2004, a unskilled person's earning is rupees 100. So in 2012, at least 300 per day. We assess 9,000 per month. Your Lordship, on the presumption and assumptions, kindly consider a student's, a family, kindly just compensation. Who should be the just compensation?
Yes.
If the amount which was awarded by the tribunals, supposing after litigation cost, parents will get, and that will be deposited in a fixed deposit bank. What for rest of life they are earning 6%, 7%. Kindly consider the just compensations on the basis so that they can survive, because they have no issues. Two sons, two CBSE students after completion of CBSE, one was he was doing a ITI, a non-technical the engineering course. He is not a IIT student. He was an ITS student. That's reflected in the annexure. In the not annexure, in the exhibited document. And in this case, in the paper book, I have annexed the admit card and also the result sheet that he was a student and Learned Tribunal has admittedly taken. He was a student of CBSE class student. Kindly consider, think about the matter. This is my summons of two applications.
Yes.
My lord, on the last occasion about the ITI student, I have already submitted, my lord. My learned friend has
If you may.
repeatedly says that learned tribunal has arbitrarily given this award or taken this income of 6,000 only. But the claim application, my lord, see, it has been claimed 5,000 and PW1 has said it is 5,200 and the tribunal has taken 6,000. What more? And my lord, I have on the last occasion done
This is in FMA 38.
FMA
38. ঠিক করে বলো প্রথম কেসটা আছে FMAT
38.
Yes.
So here the amount claim was how much? 5 lakh.
the first case.
Here the amount.
No, how much claim was made in the first case?
Claim 20 lakhs. 20 lakhs.
FMAT 38.
Yes.
20 lakh.
যশা আমাকে জিজ্ঞেস করছে আমার কেস
Wait,
20 lakhs.
No. I'm just asking the quantum. How much quantum was claimed?
My lord,
20 lakhs.
for
FMAT 38.
38.
38, my lord, it was claimed as in the claim application.
Kindly see my paper.
My lord, 4,000 was
4,000 that
Total claim.
এই রাখো 20 lakhs. গুলিয়ে ফেলছে মানে kindly see my paper book page
Okay,
page
so
4,
total claim was 20 lakhs.
20 lakhs.
And it was stated that 4,000 per month.
per month, my lord, in the claim application. And for the PW1 has come before the learned tribunal and has said that it is 4,000. And the learned tribunal has taken it 5,000. So how he is aggrieved? How is he aggrieved with the income? Because whatever he has claimed in his claim application, whatever PW1 came before the learned tribunal and said 4,000, learned tribunal has taken it 5,000. What more?
No.
He can claim there 20 lakhs, 50 lakhs, whatever. It cannot be a bonanza. It is very unfortunate that two children of the same family died. But
Malad, in the deposition of Malad, the father of the deceased son. In fact,
Anyway, here the question is only quantum, okay?
yes, Malad, here
Question-
Malad father has not says. I paid
whatever it is.
Malad 5,000 in deposition.
Whatever
Your
it
lordship kindly see Malad.
Okay, I shall see everything.
Nagappa versus Goodall, where the Supreme Court says even if the claim amount or the claim is, my lord,
Anyway, let your learned friends submit their
claim amount is lesser than the,
Let
my
him
lord, the
finish,
just
my lord.
No,
compensation.
let your learned friends
Yes,
submit.
yes. I'm finished my argument.
my lord, I will give my written argument. Written notes of argument, give me some time. I will submit.
Yes, record an order.
My lord, kindly make it CAB, my lord, he will.
Learned
Next week, I will give Monday.
advocates for the parties are present. Hard learned advocates. Hearing is concluded. However, learned advocates are granted opportunity to file written notes of arguments.
My lord, I will not file, my lord, I am only.
Let this matter appear on 4/12/2025.
4/12. No, my lord, next Monday.
Okay, 8/12/2025 under the heading to be mentioned.
I'm grateful, ma'am.
Next Monday, it will appear as to be mentioned.
Yes.
Only written notes of arguments, no arguments.
Monday, my lord, I have some delivery. It will be placed on, my lord, on the 6th. It will be helpful.
No.
Shonibar.
You see, no arguments are required, only
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 he,
written-
my lord, she intends to file written notes of argument.
yes. Arguments are not necessary.
And if I feel, my lord, my time permits, I can make, my lord, written notes of argument.
Yes.
I'm grateful to you.
I'm grateful to you.
Next day, this speaks as
8-1, 8-12,
8/12.
8-12-2025.
8 তারিখ।
Item 29.
My lord, I am for the appellant insurance company. First time it is coming, my lord.
Where is the? Oh, you are.
First
It's
time.
happening for the first time.
First time, my lord, and
Yes.
we have already deposited the statutory amount. My lord, I am paying for stay, and my lord, there is a delay of 11 days.
Where is that? Oh, have you served Section 5 application?
No, my lord, this is the first time it is coming.
So
Lord,
serve Section 5 application. Thereafter, I shall take it up.
Lordship. My lord, this is only 11 days delay, my lord.
Whatever it is, you see, I cannot take up Section 5 without the hearing the other side.
Lordship.
Yes, record an order. Learned advocates for the appellant is present. Let the copy of the application under Section 5 of the Limitation Act being Can 1 of 2025 and copy of the application for stay being Can 2 of 2025 be served upon the respondents and affidavit of service be filed. Let this matter appear on 9/12/2025.
Lord, my lord, the execution proceedings is going on. That's why, my
When
lord.
is the next date?
Next date is the next week, my lord. That isn't there.
Okay, as the matter is sub judice before this court, the parties may seek adjournment before the learned executing court, which may be considered.
Lordship, I'm grateful. কোনটায় আছো নিউ ইন্ডিয়া নিউ ইন্ডিয়া
বলে দিন, বলুন না।
আমি জানি না তুমি জানো তো তোমার সেটা
দর্শকদের দিন দিলে কি আপনি ওটা দিন না, ও দিয়ে দিয়েছেন, কিছু বলতে হবে না।
না তুমি আসো কোনটা না আমি কি বলবো না তুমি আসো কোনটা
Yes,
বলে নিন দুটো
30.
Yes, madam. I'm appealing for the claimant's appellants, my lord.
So, Can 2 is for what?
But one is for delay, my lord, for 62 days, and 2, my lord, for taken note of attainment of majority of in respect of appellant number 2, 3, and 4.
Yes, record an order. Learned advocates for the parties are present. The application for condonation of delay Can 1 of 2025 is taken up for consideration. Our learned advocates peruse the petition filed. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condonation of delay. That thus the delay of 62 days should be condoned. Thus, the application under Section 5 of the Limitation Act, being Can 1 of 2025, stands allowed and disposed. Next, the application Can 2 of 2025 is taken into consideration. In the instant application, it is the contention of the appellant that the appellants have attained majority as reflected in the Aadhaar card annexed to the petition. So all of them have attained majority.
2, 3, 4. One is
Okay.
major, my lord.
Okay. The applicants, thus the application filed by applicant number 123 being appellant number 234 stands allowed. Let the appellant number 234 be shown as major, the department to carry out the necessary amendments within a period of 2 weeks.
My lord,
Liberty to mention.
my lord, my formal objection to the delay, I may be recorded.
I have not recorded your consent. I've just recorded hard.
It may be referred to the Lok Adalat.
Acha. As this is a motor claim case and may be settled between the parties, the matter is referred to the National Lok Adalat to be held in the month of December. Fixed 7/1/2026 for report of the National Lok Adalat.
Affidavit of service may be kept in
The affidavit of service be kept with the record. Yes, the appellant, the insurance company has appeared, but the vehicle owner has not appeared.
They are not
They are
usually.
not,
Okay.
They are not because my lord, they have already my lord, already paid the awarded sum, my lord, in the tribunal.
Okay.
They have taken that liability. তুমি দেখো লোক অদালতি হয়ে গেল করে দাও এমন কিছু না
আপনি বলুন।
31, my lord, I am for the respondent claimant. Cross objectors.
Cross objection is not appearing.
Cross objection is not appearing, my lord.
So can one is disposed?
No, my lord. My lord, this is a appeal of insurance company pursuant to this honorable court's earlier direction. My lord, I have secured the entire awarded sum before my lord's court. My lord, may I just show that by this challan, my lord? Your lordship will kindly, my lord, today make this stay absolute. And my lord, as my learned friend states, my lord, that he has filed a cross objection.
So let that appear on the next day. In the
Lordship.
meantime, let it be sent to Lok Adalat.
Lordship, your lordship will kindly make this stay absolute, my lord, today.
Filing the paper book today.
Yes, record an order. Yes, file the paper books. Learned advocates for the parties are present. As the appellant insurance company has secured the entire awarded sum in terms of the earlier order, the ad interim order of stay of the record to din to
Record.
ad interim order of stay granted earlier shall continue till disposal of this appeal.
Lordship.
The paper books filed by the respondents number 1 be kept with the record. The cross objection being COT
124 of 2025.
124 of 2025 be listed on the next date fixed. Stop. As this matter refers to the motor accident claim, which may be settled, the matter is referred to the National Lok Adalat to be held in the month of December. Fix 7/1/2026 for report of the National Lok Adalat.
7-1.
Yes. কিন্তু ডিপার্টমেন্টকে তো অর্ডারটা পাঠাতে হবে, ওরা যদি জানে যে এটা লোক আদালতে হবে, ওরা তখন তো নিয়ে যাবে। যেগুলো লোক আদালতের সই হয়ে গেছে না, এগুলো ইমিডিয়েটলি পাঠান ডিপার্টমেন্টে। এবার এখন একটা প্রশ্ন হলো কি, সেক্রেটারি, হাইকোর্টের সেক্রেটারি কি মানে লিগাল সার্ভিস কমিটিকে জেনে নি যে আপনার কি সরাসরি পাঠাবো না ইয়েতে ডিপার্টমেন্ট, সবই ডিপার্টমেন্ট।
Bless your lordship.
This is my application. Only my lord, application was stay, my lord. But it's within time, my lord. This first time appearing, my lord, I am paying for interim stay, my lord. I have deposited the statutory amount of 25,000, my lord.
রেকর্ডটা দিন। Yes, record an order. Learned advocate for the appellant is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000 there shall be an ad interim order of stay of the judgment and award passed by the learned additional district judge, 5th Fast Track Court, Alipur, South 24 Parganas, in MAC case number 620 of 2022 for a period of 5 weeks. Stop. The appellant insurance company is directed to take steps to deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks.
Less
Stop.
statutory amount.
Less statutory deposit within 5 weeks. In the event such deposit is made within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General is requested to deposit the requested to invest the amount deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful.
বলো কি বলবে আরে বলবো আমি তো মামলাটা আগে একটু বল
Lord, I am for the appellant claimant. This is the affidavit service. I have served all. The case is very simple.
Can two for
Appropriate order. Lord, in this case, the claim petition was dismissed at the threshold on the sole ground that it is filed after 6 months. Pursuant to the new act, there is under 166 subsection 3, there is a stipulation that the application should be made within 6 months from the date of occurrence of the accident. We have filed after 10 days delay. Subsequently, we filed an application for section 5 for condemnation of the delay. However, the insurance company filed an application for rejection of my case under order 7 rule 11.
what is the order?
Last dated 11th March 2025.
11th
March 2025. Order number 70. Very short question is
Order number? Okay. Where is the order? Under challenge.
এই যে মেমো
The memo.
মেমোটা দিন তো।
মেমো
Oh, okay.
Milord, in this case,
yes,
but I've got
yes.
Just now, Milord, I've got telephonic instructions to appear in the matter. Would it be my lord's pleasure, Milord, to take it up, Milord, any other day, Milord, tomorrow or any other day, Milord?
Okay, not today and tomorrow. Come day after tomorrow.
Next time, tomorrow আমি overseas থাকবো।
তুমি বলে দাও।
তারপর day after tomorrow।
Wednesday.
Let this matter appear on. Okay, not today and tomorrow. Under the same heading.
এটা একটু দিয়ে দিন তো দাদা। Not today and tomorrow. So it will be on 3rd. তাহলে এটা 3 তারিখে থাকবে। 3 তারিখ। Grateful to your lordship. Affidavit service টা kept on করে দাও। মানে affidavit service be kept on record.
Yes. Affidavit. আচ্ছা এই অর্ডার লিখে নিন তো learned advocates for the parties are present. আগেটা learned advocates for the parties are present. The otherwise you can do one thing, you file it day after tomorrow. তাহলে অর্ডার দরকার নেই ওটা লেখা। File it day after tomorrow.
এটা দিয়ে দিন affidavit service টা দিয়ে দিন।
But in this matter, I'm for the appellant. What happened was the application, there was a delay of 10 days, there is an application for condonation of delay. During pendency of this, the appellant died, sole appellant. Substitution petition is pending. But in the meantime, after service of notice, it appears.
To see how many applications are required to be heard now.
all the applications, except
Initially, you see, the matter is not yet admitted.
No, except the application all.
So section 5 is to be disposed.
Yes.
So that is not disposed.
No.
The liberty be given to file the opposition because the delay is inordinate delay.
No. First of all,
My lord.
Section 5 application is to be disposed of.
Yes.
But that could not be done. In the meantime, the sole appellant died.
Sole appellant died, my lord.
Yes, then
Substitution application is pending.
yes.
After service of notice upon the heirs, it appears that respondent number 1 has also died.
Yes.
Lord, therefore, my lord, substitution application has to be filed.
Another.
From the हाँ, respondent one's wife. वो तो आगे ही मरा है.
No,
हाँ?
my lord,
Gautam.
meanwhile, another person, legal heirs of the
Yes, yes.
also died, my lord.
That's why.
These are death certificates.
So it's better you come with necessary particulars.
Yes.
These are death certificates, my lord.
Anyway, you file it.
My lord, let
When
it
the
be
matter comes, you file it.
let it be supplied to us, my lord, we shall file it.
Yes. Learned advocates for the appellant and learned advocate for your for
Respondent.
Respondent
number
number 1.
1 are present.
My lord, kindly noted it the name Basudev Bishas. I am appearing.
Respondent number 1
Basudev
Basudev Bishas are present.
Gautam Bishas
It
died.
is submitted by the learned advocates that respondent number.
No, my lord, the name Basudev Bishas, I am appearing. That is out
Which
of
respondent died?
out of two, original respondent died. Thereafter, substitution has been filed and the notice has been served to the 2 persons of the legal heirs, but out of them, one has been already died. Meanwhile,
Learned advocate for the appellant and learned advocate for the proposed respondent who seeks to be impleaded on
my lord.
account of death of the original respondent are present. It is submitted by the learned advocates that the respondent number 2, who ought to be substituted in place and state of the original respondent, has passed away in the meantime.
My lord.
Stop. Thus, in the facts and circumstances, the learned advocates are granted liberty to take necessary steps to file the substitution application.
My lord. My lord.
On the other hand, if you come with the power, you can file power also on behalf of the substituted heirs of the
already filed.
other heirs of the respondent number.
No, heirs of the respondent. Respondent
Two.
Proposed respondent.
Well, it is the duty of the
Anyway, let him serve.
Yes.
Kindly supply us to
It
the
will
name of the legal heirs.
legal heir.
Yeah.
Name of the legal heirs.
Huh?
Otherwise,
Yes.
the name of the
Uh-huh.
legal heirs name. Well,
There is.
name of the legal heirs.
Substitute for the end.
And for the respondent number 1,
Appellant is not here. Okay, then not today.
35 minute, kindly make it not today.
Petitionটা তাড়াতাড়ি পাঠিয়ে দেবেন।
Before your lordship rising,
Yes.
item number 38, last occasion your lordship was pleased to fix at 3 p.m. But the time has not is not made.
Item 38.
38.
Well,
The time
anyway,
is not appearing in the list.
okay, I'll take it up at 2 p.m. At 2 p.m. 2 p.m. এ তো কোনো fixed matter নেই। I'll take it up at
This matter was fixed on 3 p.m.
no. At 2 p.m. if both parties are present, I'll take it up. Otherwise, I'll take it up at 3 p.m.
Lordship.
Item number 37.
38.
37 item number.
38. Item is follow him.
Huh?
35 not today. My lord, kindly make it not tomorrow, my lord.
35.
35. Yes, lordship, my lord, not today. Kindly make it not tomorrow.
You are for?
I am for the appellate.
Okay. Not today and tomorrow.
উপরে যাও, নিয়ম বলে judgment number 1 and 2.
Yes. Thus both the appeal being FMA 1187 of 2025 and COT 104 of 2025 stands dismissed. Order dated 30th August 2024 passed by Learned Additional District Judge 5th Court Krishnanagar Nodia in MSC case number 75 of 2023 is affirmed. The trial court's records be sent back.
And also they are directed to already Liberty kindly India to withdraw the water amount they have already deposited here.
Okay. Okay, respondent number 1 to 4.
Let's see. 1 to 4.
Yes, claimants are permitted to withdraw the awarded amount.
Lordship.
Dispose of.
এটা বললাম না, এটা তো এই মামলা এই সাইটেশনটা দিতে হবে, এটা একটু আমার কাছে
Number 36.
Grateful Lordship.
May please your lordship, I am appearing for the.
My lord, I am for the
appeal
respondent 1, 2, and 6.
This is my affidavit of service.
Two applications, can 1, can 2.
Can 2 is the application for condonation of delay. Section 5 application.
Yes, let me see.
Yes, my lord, I have some objection, my lord. There is inordinate delay.
Okay.
Follow petitioner judgment.
Can 1 is for?
Can 1 is for my lord injunction, application for injunction.
Okay, let can 2 be taken up.
Can 2 is the application for limitation in filing the second appeal. Have your lordship got it?
Yes.
Can 2 application. $2,340 delay in filing the second appeal. My lord, I have stated the grounds in paragraph 4 of the application for limitation. ভুবনেশ্বরী জাজমেন্টটা দে আর এইসব হচ্ছে দি জাজমেন্ট আমার তোমাকে দে অফিস কপি আর দুটো জাজমেন্ট জজ সাহেবকে দেয়া দে ভুবনেশ্বরীটা দে ভুবনেশ্বরী আমার অফিস কপি ওটা দে ঠিক আছে
Thank you. Yeah, no issue.
Yes, did you file any opposition to this?
No, my lord, I am not filing any opposition because most of my objections are, my lord, based on point of law. Only some are factual. My lord, may I invite your lordship to the paragraph number 4?
Paragraph 4 is the ground, that is
Yes, my lord, that
her knowledge and
yes,
illness. These are
that
the
is
two grounds.
that is according to them is the sufficient cause, my lord, of condoning delay before your lordship. Whether this is sufficient, my lord, I am inviting your lordship to that particular perspective, my lord. Kindly
আমি আগে বলছি আর্গুমেন্টটা
No, no.
yes we will get sufficient time
No, no. Very well, very well. Let me seek clarification from him.
my lord, kindly comes to their medical certificate once. That is the only annexure.
Yes.
First of all, this annexure has been this particular medical certificate, it has been granted by a homeopathic practitioner. The homeopathic practitioner on 1st of February 2025 certifies that Thupawala Sardar, such and such age, come under my observation and treatment for long, that is 25th of August 2016, suffering from hypertension and peptic ulcer. At present, she is suffering from trembling hands. Does it anywhere indicate, my lord, I am asking myself, which any condition at all which will give an indication that she was suffering from memory loss?
So two things, you see. Knowledge or information and this illness.
The illness was that, my lord, she filed an appeal, then she simply forgot. I am, my lord, indicating that particular the portion of the paragraph.
Yes.
My lord, in the middle portion, the paragraph runs thus: the petitioner, due to old age ailment, also could not remind about appeal during the long 8 years prior to meeting of the Mohorar of the Bakura court. She simply forgot. Does it anywhere indicate in the medical certificate that has been annexed by my learned senior friend that she was suffering from a condition which would corroborate that yes, she lost her memory because of that particular medical condition?
82 years age, this is not disputed.
82 years in age, my lord, I'm not disputing that.
Age is not disputed. The other is she was under treatment or nothing unusual.
Yes.
Okay.
But
and the third is knowledge. Whether she was intimated. The other thing is this: the appeal was allowed in part also.
Yes, it was. Now, my lord, she filed the appeal in 2009. Subsequently, the appeal was partly allowed in her favor in the year 2016, 31st of May 2016, the judgment was passed. So, my lord, since 2000, if 2009 is considered, she is not 82 then. She has an elder, she has a major son who is the signatory, who is the authorized signatory here, my lord. So that major son, if my lord kindly takes up the cause, my lord kindly takes up the cause title, my lord will see that the address of the appellant and the person who is affirming the affidavit on behalf of the appellant, the addresses are the same. They are living under the same roof. None of the family members, my lord, could not remember during the long 8 years that yes, there was a file in the Bakura court. And my lord, there is another very important aspect, my lord. Although there is, my lord, practice may be different, but may I just praise this? My lord, kindly takes up the judgment, the impugned judgment in the memo.
Yes.
Yes. So date of delivery of judgment is just before the short cause title, my lord. Date of delivery of judgment is 31st of May 2016. This appeal coming on this day or having been heard on, yes, my lord.
Yes, this is.
Yes, my lord, the very first page.
Okay, memo.
Yes, memo, the impugned judgment, the very first page of the judgment.
Yes.
Yes. So, my lord, right below the short cause title, date of delivery of judgment, just under that, this appeal coming on this day or having been heard on 16th of September 2015, 29th February 2016, 27th May 2016, 4 days before passing of the judgment. The client did not instruct a learned advocate. The learned advocate, my lord, as we all know, we are just, my lord, the spokespersons. We are creature of instructions, my lord. So, my lord, if
When was
proper
the certified copy obtained? Let's see.
Certified copy obtained, my lord, in the year of 2024, August 2024.
Oh, this copy was not obtained earlier.
No, my lord, copy was not obtained.
2024.
Yes. So, my lord, the Honorable Supreme Court says, my lord, three very pertinent, my lord, considerations that the parties have to be continuously diligent. There must have to be, my lord, bona fide of the parties, and the party, nothing on the record should indicate that the party wants to drag the suit or the proceeding till perpetuity. These are the three considerations. My lord, may I just place one judgment of this Honorable Calcutta High Court, my lord, Division Bench, FAT number 33 of 2024. This was passed by the Division Bench, the Honorable Division Bench of this Honorable Court, my lord. My lord, kindly takes up paragraph 42. My lord, in paragraph 42, the Honorable Division Bench before this judgment has considered the entire jurisprudence of how the delay condonation has been happening in the Indian courts, especially, my lord, in the view of the judgments of the Supreme Court through the years. So this particular judgment, this Pathapati Subba Reddy, it was delivered on in 2024. So, my lord, the para 26 of that particular judgment, as my lord can see, it has been quoted. On harmonious consideration of the provisions of law as aforesaid and the law laid down by this court, it is evident that law of limitation is based upon public policy that there should be an end to litigation by forfeiting the right to remedy rather than right itself. A right or the remedy has not been exercised or availed of for a long time must come to an end and cease to exist after a fixed period of time. This is the departure from the earlier decisions. The earlier precedents, they tell, my lord, that yes, the sufficient cause is there, it is well and good. Now this is a departure by the Honorable Supreme Court itself. The Honorable Supreme Court says, yes, the delay is also pertinent. If there is an inordinate delay, you must take into consideration of that. The provisions of the Limitation Act have to be construed differently, such as Section 3 has to be construed in a strict sense, whereas Section 5 has to be construed liberally. In order to advance substantial justice through liberal approach, justice-oriented approach, or cause of substantial justice may be kept in mind but the same cannot be used to defeat the substantial law of limitation contained in the Section 3 of the Limitation Act. Courts are empowered to exercise discretion to condone the delay if sufficient cause has been explained, but that exercise of power is discretionary in nature and may not be exercised even if sufficient cause is established for various factors such as where there is an inordinate delay, negligence, and want of due diligence. Well, this particular applicant, she simply forgot along with all her family members. I am pressing on this. Merely some persons obtained relief in similar matter, it does not mean that others are also entitled to the same benefit if the court is not satisfied with the cause shown for the delay in filing of the appeal. And my lord, merits of the case are not required to be considered in condoning the delay. And finally, delay condonation application has to be decided on the parameters laid down for condoning the delay and condoning the delay for the reason that the conditions have been imposed tantamounts to disregarding the statutory provisions. So, my lord, these are the things that have been laid down by the Honorable Supreme Court. Now, my lord, let us inspect what the Honorable Division Bench of our Honorable High Court has observed based on this particular judgment. My lord, kindly comes to the paragraph number 43, the very next paragraph. In the said paragraph, the Supreme Court highlighted that justice-oriented approach and liberal approach in condonation of delay cannot be used to defeat the substantial law of limitation. Exercise of power, it was observed, is discretionary and may not be exercised even if sufficient cause is established for various factors such as inordinate delay, negligence, and want of due diligence. Now, my lord, very importantly, the next paragraph. Notably, two important deviations were made in Pathapati Subba Reddy from the previous line of judgment holding the field. The first, as opposed to the previous position, that the length of delay is not material, but the sufficiency of the cause is. The Supreme Court now held that the length of delay, if inordinate, would be a relevant consideration for refusing condonation of delay. Secondly, as opposed to the division bench of this court in State of West Bengal versus Vishwanath Bhattacharya, it was held by the Supreme Court that the merits of the case are not required to be considered in condoning the delay. So, my lord, the huge delay. The delay is, my lord, of 8 years.
So the appeal was disposed in 2016.
Yes, my lord. 31st of May 2016, the judgment was delivered. After that, no follow-up by the appellant whatsoever, by any of our family members. In fact, the signatory in this present case, my lord, on behalf of the appellant. There cannot be, my lord, said, my lord, subject to your lordship's correction, that there is due diligence, at least on the part of the appellant or our family members.
Which paragraph? Which is the paragraph? Okay.
My lord, the paragraphs are 40, 42, 43, and 44. And my lord, another very short judgment of the Honorable Madras High Court. May I just, for the pertinence of the medical ground.
Yes.
And I'd invite your lordship, my lord, to paragraph 2, because the fact here is important, my lord. Copy never. An appellate order was issued, my lord, is there? An appellate order was issued on 23rd of February 2016. As per Section 86 of Finance Act 1994, the appeal should have been filed within 2 months from the date of receipt of the order. Consequently, in this case, the appeal should have been filed on or before 23rd of May 2016. The petitioner presented the appeal before CESTAT on 13th November 2023, along with an application to condone the delay of 2727 days. Since such application was rejected, the present writ petition was filed. Now, my lord, kindly comes to paragraph 6. The reasons stated by the petitioner are that he was suffering from chronic disc prolapse at the L4, L5 level, that is sciatica, with regard to the medical certificate produced by the petitioner in that regard. CESTAT recorded that the conclusion that the certificate merely states that the petitioner was under treatment from 2016 and not that he was unable to undertake day-to-day affairs during the said period. My lord, kindly comes back to the medical certificate. The medical certificate does not indicate that she was bedridden from 2016 or she was suffering from a condition that actively affected her memory. Based on the reasons stated by the petitioner and the evidence submitted in support thereof, in my view, the conclusion of CESTAT in this regard cannot be faulted. Consequently, no case is made out for interference. That's all, my lord.
Yes, now you submit.
First of all, my lord, the appellate petitioner is belong to scheduled tribe community, and she reached at the age of 82 years. When the appeal was heard in presence of her learned advocates. In paragraph 4, my lord, I have stated clearly that there was no communication. When the appeal was heard, she was at the age of 72 years or more, 74 years.
Yes, page?
74 years.
Okay, which paragraph you have stated that?
Page 4, paragraph 4. Paragraph 4 and 5. Moreover, my lord, being the tribal lady, when questions of law regarding the inheritance of the property involved in the suit, the my lord, appellate court decided that
No, you
suit is
see, in
decreed
section
in part.
5, the court cannot go into the merits.
My lord, I am relying.
For a short period, yes.
No, I am relying, my lord, upon the judgment passed by the Honorable Supreme Court in 2013-12, volume 12, Isa Bhattacharya versus Managing Committee, Raghunathpur, Nafar Academy and others. Relevant paragraph in my lord. Paragraph number 21.
My lord, may I just interject for one moment, my lord?
Yes.
The Honorable Calcutta High Court judgment that I have given to your lordship, the paragraph 50 considers the Isha Bhattacharya that my learned friend
This was
cited.
considered?
This was considered.
Okay.
I am relying, my lord, another judgment passed by the High Court, Honorable High Court of Chhattisgarh in Bhuneshwari Bai versus Gokul. Paragraph number 8, 9, 12, 10.
Yes.
Well, the term sufficient cause should be understood in their proper spirit, philosophy, and purpose regarding being had to the fact that those terms are basically classic and are to be applied in proper perspective to the obtaining fact situation. Well, there was no communication in between the learned advocate and also the appellant since 8 years or more. Well, it is clearly stated in my paragraph number 4 that when she visited the doctor's chamber, at that time suddenly she was met with one Mohra of the learned appellate court. The learned appellate court is at Makura at the same time, and my lord, the appellate court's order was not communicated by any of the persons. My lord, being a tribal lady, she had no knowledge But the signatory, when she had come to knowledge about the, my lord, decision fate of the appeal, decision of the appeal, immediately, my lord, she, being unable to attend before the Honorable High Court due to her old age, my lord, she also instructed her son to file the second appeal. My lord, in the second appeal, my lord, substantial questions involved in law that will be, my lord, decided by the Honorable Division Bench, that will be admitted. But here, my lord, when substantial justice may be given to the appellant when she was ignorant about the fact of the decision of the lower appellate court. My lord, here another Supreme Court, this, my lord, Bhuneshwari Bai versus Gokul, in this judgment, my lord, the Honorable, Honorable High Court of Chhattisgarh relies upon the decision of the Honorable Supreme Court in the matter of Esa Bhattacharya and also, my lord, M. Balkrishnan. N. Balkrishnan, V.M. Krishnamurti, 1998, 7 SCC 123. My lord, when the petitioner appellant, petitioner is entitled to get justice, because, my lord, the court has to avoid the injustice to a person. This is the, my lord, propositions of the law. Therefore, Limitation Act does apply under Section 5 to condone the delay when injustice is given to the appellant by the lower appellate court. So, court should have to give the fair justice to the appellant. Here, questions of law involved in the appeal was, my lord, that the appellant filed the suit for declaration of title and permanent injunction on the ground that the appellant belonging to tribal community and a lady, a daughter of tribal community, is entitled to get the property of her father in absence of son. But they are aboriginal Hindu and they are governed by
on merits. Okay.
that is merit
You
by
argue that on merits.
but yes, but my lord, court has passed the order passing the decree on part.
Whether you will be permitted to enter or not, that is the question.
My lord, kindly consider this. That
Because you see,
limitation
the
is
period of delay is 8 years. Whether this court will be believed that the advocate did not.
But my lord, kindly consider the age of the appellant.
Whether your
Kindly
case is
consider
believable
the
or
age.
not.
Kindly consider the age of the appellant. Appellant age is
case
82 years.
That you did not have knowledge for 8 years, whether this case is believable. That is the court has to consider. If the court believes your case, the court will condone. If the court does not believe your case, then the court will have no other alternative but to refuse.
My lord, here in paragraph number 4, my lord, it is
You see,
clearly
there are two
stated.
grounds. One is this medical ailments, the other is knowledge. So the court accepts your
She had
medical
no
ailment.
knowledge about
That
the
means
order.
knowledge is there, this medical ailment is there.
No,
Now,
she had no
medical
knowledge.
ailment is accepted by the court, whether court will accept your plea of knowledge. That is the thing.
My lord, she had no knowledge about the decision of the passed by the appellate court. This is, my lord, clear statement in paragraph 4 of the, my lord, application for limitation. My lord, while she visited the doctor's chamber, there, my lord, once she was met with the Muhrar of the learned advocate, who, my lord, stated that her appeal was, my lord, decreed in part, and therefore, my lord, that is sufficient cause to believe that she had the knowledge about the decision of the first appellate court on 13th August 2024. And my lord, she hurriedly took a step instructing her son to appear to visit the, my lord, learned advocate of the Honorable High Court and, my lord, to file the second appeal. Moreover, my lord, the doctor's certificate, it is clear statement that is at page 7, certified that Thupabala Sardar, 82 years, wife of late Atul Chandra Sardar of the village Diuli, post Mulian, P.S. Sidwan Dismakura came under my observation and treatment for long time from 25th August 2016. But this should be believed. He may be the doctor, homeopathic doctor, but he has the degree like MBBS degree. But it should be believed. There is no homeopathic hospital. When she was under the treatment of
Your illness may not be disbelieved, but the question is that you did not have knowledge whether this is believable or not. That is the question.
well, this is believable because of my lord, she clearly stated in paragraph number 4 that my lord on 24th August 2024, my lord, she had got the knowledge from a mohrar of the learned appellate court at Makura. But there is no any document to be submitted by the my lord respondent regarding that the she was not met with the mohrar of the learned advocate of the Makura.
How can I?
Well, this is the
produce that, sir?
situation.
Well, there must be 50 mohorars, my lord, in Bakura court at least. No, nobody is particularly named. Not one SMS, not one phone call in the 8 years. If this is to be believed, my lord, a floodgate will open before this honorable High Court, and my lord, everybody will try to revive their old suits.
ওটা the same judgment দেওয়া আছে এইসব হচ্ছে যে কভার করে আছে my lord in the judgment Bhuneshwari Bai, my lord, she was the my lord lady belonging to scheduled caste community, my lord. He had got no idea about the my lord fate of the appeal in filing the application for limitation. Therefore, my lord, there was delay near about 8 years, and that was condoned by the my lord Honorable High Court at Chhattisgarh, relying upon the decision, my lord, on Esa Bhattacharya versus Managing Committee and N. Balkrishnan versus V.M. Krishnamurti, 1998 Supreme Court, my lord. Well, it is clear, very clear that a tribal lady having reached at the age of 82 years could have no idea about the my lord decision passed by the learned first appellate court, my lord. Paragraph 5, my lord, it is clearly stated that she is belong to tribal community, my lord. In tribal community, a lady cannot get the idea about the my lord suit until and unless the learned advocate explained that and communicate day by day to him the result of the case.
See, I am just considering your injunction application. Paragraph 7, what have you stated? Is still now in actual physical possession of the suit properties. Page 7 of the injunction application. That means whether you have given any indication about how you came to know.
Paragraph 7. Paragraph 7. Paragraph 7, my lord, it is the abandonment that is still now she is in actual physical position of the suit
position, you see, after the learned lower appellate court decreeing the suit in part, you are now in possession.
Paragraph 7, my lord, there is abandonment. The petitioner came to know that the defendant support is in paragraph 7, it is, my lord, abandonment of the appellant that my lord, the learned lower court appellate decreeing the suit in part, the defendants, my lord, she has come to knowledge about the decree in part when she got the certified copy of this. order, judgment and order passed by the learned appellate court. So, my lord, when the defendant
The application
starts
for certified copy made in 2024.
2024. And let the limitation application be considered and allowed, my lord. This is a second appeal, my lord. Substantial question involves in law. When my lord, the appellant petitioner will satisfy before the honorable division bench, my lord, then appeal will be admitted. So, my lord, limitation application should be condoned, my lord. There is no, my lord, negligence on the part of the, my lord, appellant petitioner. Because of, my lord, she is the lady of 82 years of old, my lord, having no, my lord, total memory about the day by day running of the suit and condition of the suit, until and unless that is communicated by the, my lord, learned advocate appointed by her in the appellate court. It is
Yes,
not
record and
possible.
order. Learned advocates for the parties are present. You are representing all the respondents.
No, my lord. 1, 2, and 6.
Respondent number 1, 2, and 6 are present. Service is complete upon all the respondents.
Service complete.
The application for condonation of delay is taken up for consideration. Our learned advocates. The hearing is concluded. Let Can 2 of 2025 appear for orders on 10/12/2025. Yes, hearing concluded, order is.
Lordship, kindly consider that injustice may not be done against the appellant.
Yes, I have to consider in accordance with law, whatever
Yes,
is to be done.
Grateful to your lordship.
Grateful to
এটা ইয়ের মধ্যে ফাইলের মধ্যে রেখে দিন তো ভেতরে ফাইলের ভেতরে
My application for condonation of delay.
appearing on behalf of the respondent number 1, madam.
This
37, give the records.
service my affidavit of service may be taken on rep. Condonation of delay. The delay is for 285 days, but my lord, probably I'll have the benefit of section 14 of the Limitation Act in respect of a part of it. My lord. Initially, the impugned order was passed, but on 3rd April.
Before start, madam, I want to file my opposition against properly.
Why didn't you file?
Just service has been made, but
oh, okay. Record and order.
And I'll just point out if
you file the opposition, whatever he wants to say, you file your reply also. Learned advocates
the only
for the
thing
parties are present. You are representing all the respondents.
Respondent number 1.
Learned advocate for the appellant and learned advocate for the respondent number 1 are present.
directions may be passed in respect of all the response. Otherwise, next day some other respondent will come and ask for time once again. Madam, I'll serve this.
Cost service.
I've caused service on all the respondents.
Okay. The application for condonation of delay is taken up for consideration as learned advocate for respondent number 1. 6, time to file affidavit in opposition. Such time is granted. Let affidavit in opposition be filed on or before 8/12/2025. Reply, if any, by 10/12/2025. How soon can you file your reply?
As in 3 days, my lord. My lord will give me 3 days, I'll file it.
Okay, 11/12/2025. Let this matter appear on. So it has to appear in the month of January, because thereafter 2 weeks this bench may not sit. Okay, 12/12/2025.
Deeply obliged. Deeply, the only thing an appeal was preferred from the impugned order earlier. There were some errors that was withdrawn, and this was filed afresh. That is why the delay. Deep.
Not yet.
I beg to appear on behalf of the respondent. I mean, respondent number 1 to 7. Other respondents' appearance has been dispensed with at the time of admission.
They were the pro forma defendants in the suit.
This is application for?
Application for vacating interim order.
Whose application is this?
My application, respondent number 1 to 7. Can number 3. Now, can number 1 was the injunction that has been granted at the time of admission hearing. Thereafter, this.
What is the ground for vacating?
Yes.
May I submit my opposition?
Before me not going into the, I am.
Filing opposition, do you want
Yes.
to reply?
No.
There was a direction.
Not required. Not required. I will reply verbally.
Yes.
The plaintiff, this is opposition to the injunction application.
There was no direction.
Regarding vacating.
No.
You are moving this vacating application.
Yes. Vacating application.
So let me see. Consider this.
Now, my lord, the respondents are the plaintiff before the learned trial court.
Yes.
Suit was for declaration of right title interest and injunction in respect of the suit schedule property. Judgment of affirmance.
Yes.
The learned suit court was pleased to decree the suit in my favor.
Yes.
Holding that we are in possession and we are the owner of in respect of the suit schedule property. The crux of the matter concisely is this, that my predecessor interest has purchased the suit schedule property from their predecessor interest of the defendant. Kiran Shankar, that is our predecessor, has purchased the property from one Muchiram Parui, that is their defendant's predecessor. Now, in the year 1976, precisely on 2nd of April 1976. Now, after that purchase, Kiran Shankar, that is our predecessor, has become the owner and established his right title interest over the suit schedule property, thereby recording name. Everything has been exhibited. Now, the problem started after the death of both the predecessors, the original owners, Kiran Shankar. The defendants are started disturbing.
Application for vacating, that is can
3.
So what have you prayed? Direct the opposite party to remove bamboo.
Yes.
And wood material.
No, I'm going there. Your lordship, kindly.
This is not a second appeal hearing, my lord.
I am considering your application for vacating, so I will not go into the matter of merits.
Now,
whether
what
it
happened?
should be vacated or not.
What happened, my lord? After the appeal court decree was passed, they have took possession of some portion of the property, and my lord piled up bamboos and other material. I have my lord annexed some photographs. Your lordship kindly sees the opposition of their injunction application.
Well, that is their opposition was never directed to be filed.
So just now, my lord, I have handed over the my lord copy of the opposition.
Well, I'd like to file a reply to that then. There was no direction to file opposition to my injunction application.
Otherwise, how? No. Your application.
They are.
I'm
not dealing. I'm not going into
considering his application for vacating.
He's
now
relying on.
No. I'm not relying. I'm showing the picture.
That is relying. That is relying on it.
Because that has been served upon him long prior to vacation.
Yes, there was no direction to.
Yes.
Now, this is the situation your lordship kindly sees.
Okay, regarding vacating application, what is your contention?
Now, my lord, thereafter, what happened, my lord? I thereafter immediately lodged, my lord, a diary before the concerned police station and my lord filed the execution case because there was an injunction, permanent injunction restraining them not to disturb my possession. Now, my lord, what happened? The suppressing all material facts, my lord, the second appeal has been moved. If your lordship kindly sees the admission, the question of law has been formulated. Your lordship,
That is formulated. What is the ad interim order passed? Let me see.
ad interim, your lordship kindly sees the ad interim order that will be, my lord, from the order.
My lord, kindly seize my opposition. It is annexed. My lord,
So
page number.
that is also there in the record book of
Page
the
number
lordship.
26. Opposition to the vacating application.
April 16.
Page 26. আপনারা দেননি my lord.
আমি বলে দিচ্ছি সব বলে দেবো।
Opposition, yes.
Yes, opposition they my lord, used against my vacating application, my lord, vacating interim order. That is, my lord, page appearing annexure C, page 26. April 16, 2025.
26. So this is the admission, order of
This is admission. Thereafter, my lord, injunction was granted. Now, your lordship kindly sees, prior to my lord going into the injunction part, my lord, point 3, the point 1 has been, my lord, formulated whether the courts below substantially erred in law in granting a decree of declaration of exclusive right of the plaintiff in respect of the suit property, despite partition by metes and bounds, either by way of a registered deed of partition or a partition decree, having not been proved by the plaintiff's respondent. But this is the admission. I will show your lordship from their written statement used by them in the learned trial court below.
Anyway, you see, I'm confining myself to
Why?
this. You see, this admission, I cannot sit in appeal over the order of the division bench.
Why,
You
my lord,
will hear the matter.
Why, my lord, I am submitting?
No. Now you
Because
submit why your order should be vacated. Why your relief should
because
be granted.
39(4), my lord, speaks about, my lord, the suppression of fact.
Now this is there.
Very well.
What is this paragraph number 4?
Paragraph number 4. In view of prima facie case having been made, since the appeal has been admitted for being heard on the substantial questions of law as formulated above, we are of the opinion that unless an interim order is granted as prayed for, the appeal is at the risk of being rendered infructuous. Also, we find that balance of such and such inconvenience and irreparable loss injury factors operate in favor of grant of injunction. Accordingly, both parties shall maintain status quo as regards possession and nature and character in respect of the suit property. Now, your lordship kindly see the prayer of their injunction application. That is can 1.
Can 1 টা দিন তো।
From the very beginning, we were in possession. That is why, the learned trial judge at the time of we filed a suit for right title interest over the suit property, not for possession. Not for possession. Because we had the possession with us from the very beginning. Now, after the suit court decreed, appeal court dismissed their appeal, they took the forceful possession.
Restraining the opposite, alienating the suit property, third protect.
Your lordship kindly see the prayer, page 7.
Yes.
And the nature of an injunction has been granted by the Honorable Division Bench. Page 7, your lordship got page 7 of the injunction application.
This is the page 7, and the appeal is admitted and order of status quo, and you have been restrained to alienate.
No.
Yes.
Nature and character.
No.
Restrained.
Your lordship kindly see the prayer. Their prayer.
Okay, if it is in opposition on behalf of the appellants. Yes.
The party cannot go beyond the what he has prayed before the court.
I have not. The court has granted me, my lord.
Yes, yes. April 16, 2025.
Yes, my lord.
Yes, status quo regards position.
Yes. Taking advantage of this, my lord, they have took forceful possession
Let me see what is that. This is the order passed.
on 16th of.
And what is your grievance? What they have done?
My lord, your lordship kindly see my vacating application.
Yes, page.
Your lordship kindly sees page 11, paragraph number 10.
Page 11.
Yes.
Yes, page 11, para 10. Yes.
This particular plot is, my lord, my egress and egress.
Anyway, that is there.
Yes.
Very well.
Now, my lord, thereafter, your lordship kindly sees I lodged, my lord, complaint. That is also there. I have annexed. Page 51, FIR has been initiated, my lord. Page 50, annexure C. Now, they were not in possession. That is why this prayer has been made in their injunction application, not to alienate. There is no iota in their application that status quo should be maintained, this and that.
So, this is your averments in paragraph 10.
Yes. Both the court, your lordship kindly consider, both the courts has, my lord, adjudicated in my favor, decreed the suit in my favor, declaring my right, title, interest in respect of the possession. Even, my lord, thereafter possession has been declared in my favor.
Yes, how they have dealt with this paragraph number 9, 10. How have you dealt with?
May I, my lord?
No,
May I?
paragraph number 10. This is the main
Yes,
bone of
yes,
contention.
your lordship kindly
Yes.
sees, they have denied only.
No.
Yes. 8 and 9. No,
Yes.
Please. You have got that. Party number 1 to 6.
My lord will find it on page 5, para 10 onwards.
Para 10, yes.
My lord will find from there I have made categorical statement that the appellants have always been in actual physical possession of the suit property.
Yes, para 10.
Para 10. My lord, kindly transit over page 6, para 2. Paragraph 2.
Para
Second.
11.
No, my lord, page 6 from the top, second paragraph.
Basically,
I
they
further
have stated
state, may I?
that there is sufficient space.
Yes, yes.
vacant
Para
space.
6.
Para 6, my lord, page 6, for second paragraph of the page, I further state that the appellants have always been in actual physical possession of the scheduled suit property as enumerated in the plaint, and the respondent number 1 to 7 petitioners were in never possession over the same, as would be evident from the deposition of the PW1, on the basis of which the second appeal was admitted. Possession was one of the substantial questions of law formulated by the Honorable Division Bench.
That is also incorrect submission made before the Honorable Division Bench.
Yes.
Well, subject to
I think so.
correction.
Paragraph. This is the second question of law.
Drawing aspersions against the
Station by the appellants at the time of admission.
My lord.
No. Regarding putting obstruction, what have you stated?
No, there's absolutely denied because there's no
Which
chance
paragraph?
of.
Which paragraph?
My lord, paragraph number 10. All baseless motivated, I deny the same, and petitioners are bound to strict proof thereon. Thereafter, I've made categorical statement.
8.
No, my lord, paragraph.
No, you have contended that in paragraph number 10.
My opposition, paragraph number 10.
Paragraph number, you see, your learned friend has contended in paragraph number 10 regarding putting that obstruction.
Right.
Okay.
Right.
How have you dealt with paragraph number 10?
Paragraph number 11.
Yes.
Last
how-
paragraph.
that is the
Paragraph.
question.
It
Yes.
is similarly denied that there is or was any obstruction in the ingress and egress of the petitioners, or and with the sole malified intention to strengthen their cause in the execution proceeding and further to frighten the appellants, the plaintiff lodged the baseless and manufactured complaint before the local police station. And I have been admitted to be in possession of the suit property. And thereafter, I categorically dealt with it.
Lord, from the picture,
May I?
your Lord kindly show.
May I?
See, my Lord, that the pictures which I have shown to your Lordship, that everything will be clear.
You have stated there are sufficient
Yes.
vacant spaces.
Yes, not with regard to the suit property, to an ingress and egress into his own
Let
residential
anybody be
house.
appointed.
Why? It's a second
My
appeal.
client has not come before this court.
Yes,
only to-
record an order.
Very well, my lord.
Yes.
With regard to?
I'm just passing an interim order. Learned advocates for the part appellant and learned advocate for respondent number 126.
127.
127 are present. The application CAN 3 of 2025 is taken into consideration. In this particular application, the respondents number 126 have prayed. Respondent number 127 have prayed for a direction upon the appellants to remove the bamboo and wood material piled up in front of the suit property so that the petitioners, respondents number 127, can get ingress and egress smoothly to their residential house, thereby setting aside and vacating the order of injunction dated April 16, 2025, passed by the Honorable Division Bench. Stop. It appears from the order dated April 16, 2025, passed by the Honorable Division Bench, that the appeal being admitted for being heard on the substantial questions of law, both parties were directed to maintain status quo as regards position and nature and character in respect of the suit property, and shall remain restrained from creating any third-party interest in respect of the suit property till disposal of this application. Stop. It is the contention of the respondents number 127 that pursuant to the order passed by the Honorable Division Bench, the appellants and pursuant to the order passed by the Learned Appellate Court, the appellants have piled up bamboo and woods in front of the suit schedule land to obstruct the ingress and egress of the petitioner's respondents number 127, for which one written complaint was lodged with Deganga police station.
My lord, may I? One
Yes.
thing. That is not their submission. My lord, kindly cease for
I
a
am
while.
going by the pleadings.
No, their pleadings. Their
Yes,
pleadings.
yes, let me consider the pleadings.
My lord, para 10, they have lodged they have say,
Yes.
I piled up on 29th of September 2023.
Yes.
That is, may I?
Yes.
That is the passing of the judgment and decree by the first appellate court
Yes,
on that day.
Yes.
Now, on that day, my lord sees the complaint.
Very well. I'm just considering the pleadings, please.
My lord, pleadings itself, my lord, the complaint was lodged in
Okay.
prior to the order passed.
Yes, yes. I did not say that order passed by this division bench, order passed by the appellate court.
The appellate
Yes,
court.
that I have recorded. And a complaint was lodged before Deganga police station, wide FIR number 206 of 2024, and a case was initiated under section 447, 188 and 34 of the Indian Penal Code. It is further contended appellants obtained ex parte order from this court, and for which the obstructions which still exists cannot be removed by the police authority. Stop. The appellants have denied the allegations made by the respondents number 1 to 6. It is contended by the appellants that the allegations made in paragraph 10 of the application submitted by the respondents number 1 to 7 are baseless, motivated, and manufactured. The appellants have also denied that there was any obstruction to the ingress and egress of the petitioners, and it was with the sole malafide intention to strengthen their cause in the execution proceedings. Upon hearing the learned advocates and upon considering the facts of the case, this court is of the view that the order passed by the Honorable Division Bench should be complied and there should not be any deviation from the order. Stop. However, it is also necessary for this court to examine and consider as to whether the free movement of the respondents number 1 to 7 is being infringed, which is a basic right of all the persons. As both parties have disputed these facts of obstruction, as the appellants opposite parties have disputed this fact of obstruction and hindrance in the egress and ingress of respondents number 1 to 7, it would be just and reasonable to appoint a special officer of this court to cause an inquiry and submit a report. Stop. Thus, I do hereby appoint Dash as a special officer to visit the suit property and cause an inquiry as to whether the allegations made by the respondent number 1 to 7 in allegations in application can 3 of 2025 is correct or not. The learned special officer shall visit the suit property and verify as to whether the ingress and egress of the respondents number 1 to 7 is being obstructed. Stop. Further, the learned special officers shall take necessary photographs of the suit property and the area where such obstruction is being made, and further ascertain as to whether there is any other alternative place for of ingress and egress of the respondents number 1 to 7. The learned special officer shall, upon notice to all parties and their learned advocates, cause the inquiry. Such inquiry must be caused within 2 weeks from the date of communication of this order, and a report should be submitted on or before 7/1/2026. Let this matter appear on 7/1/2026 for report of the special officer and further orders.
Let it be clear, the special officer will be only limited to the ingress and obstruction to the ingress and if any.
Yes, and further whether there is any alternative route.
Very well.
Ingress and ingress and relevant photographs.
Very well.
Grateful.
Grateful.
I have filed in opposition in injunction application.
Yes,
That
whatever
may
it is, let us see the special officer.
Let it be kept with the record. I filed
Okay, the affidavit in opposition filed to the vacating application.
No, the injunction.
No, they have filed a affidavit in opposition to the injunction application, and the affidavit in opposition to the application for vacating be kept with the record. A copy of this application can 1 of 2023 be served upon the learned special officer by the learned advocate.
1 and 3.
Application number can 1 and can 3.
One more thing, may I serve the can 2? Only.
Can 2?
Can 2, they have filed an execution proceedings before the trial court. Well, I pray for formal stay of the since the second appeal is pending.
When is the next date?
They will be in a better position to say, my lord. We have communicated the order of the.
Okay, as the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Executing.
learned trial court stroke executing court, which may be considered.
May I not get the name of the special officer?
Yes, you collect it. You see you collect the order, take necessary steps.
Grateful, Manoj.
But 39 I am appearing for the appellant here in this matter on last occasion. The lordship was pleased to direct in spite of service nobody appeared lordship recorded. However, in the interest of justice, the appellant is directed to communicate the next date of hearing to the respondents along with the copy of the injunction application. Now,
And to his application for condonation.
yes, no, this is for injunction, already this appeal was admitted and there was an order of injunction, this is for a final hearing of the injunction it has came. And I'll be
As the respondents have not yet appeared.
Respondents from the appeal court, they are not appearing. Lower appellate court, in the suit, first appellate
You can
court.
serve their advocate on record who appeared before the trial.
There is nobody, there is nobody. There is nobody. Lordship, I can show you from the, this is my affidavit of service. একবার first appellate court
So now you see, you have to take steps to cause service through the department, and the trial court's records have to be called for also. Yes, what is the order of the division bench?
Lordship will kindly take order date 17 June. The appeal was admitted, and after that, my lord. The respondents and the managers shall restrain by order of injunction from transferring, alienating, encumbering, and or parting with the possession in respect of the suit property in favor of any third party or from changing the nature of the. The DCR is the trial court record.
Yes, that will be. No, let me see the order of the division bench. Division
Yes,
bench.
17 November, 17 June 2025.
Yes.
Yes.
Okay, this application is disposed.
And disposal of anything?
No, this application disposed.
Yes, what is your affidavit of service?
Yes, I have already given one.
Earlier one.
Earlier one also I have given. This is the second time on after the pursuant to your lordship.
How many respondents are there?
No, only one, man. One and my lord.
One.
Yes, one. Actually, yes, only one.
No, others.
Nobody, man. This all pro forma. This is all my lordship plaintiffs. Plaintiffs, man.
No. Niva Devi is the respondent.
Yes, he is the sole respondent.
Sole respondent come plaintiff.
No,
Defendant. And the others are plaintiffs.
All
Yes, record and order. Learned advocates for the appellants plaintiffs are present. The application can 1 of 2. This is can 1.
Yes, my lord.
Can 1 of 2025 for injunction is taken up for consideration. As the none appears for the respondent number 1 in spite of service being made twice. Stop. Thus this application is taken up in the absence of the said respondent. Upon hearing the learned advocate for the appellant and considering the facts of the case, this court is of the view that this application for injunction should be made absolute till the disposal of this appeal. Thus this order of injunction restraining the respondents from transferring, alienating, encumbering, and or parting with possession in respect of the suit property in favor of any third party, and from changing the nature and character of the same in any manner is made absolute till the disposal of this appeal.
Only I'll be praying, TCR may be called for,
The trial court's records be called for. The appellant shall take steps to cause service of notice upon the respondents through the department. Let this matter appear on. I'm keeping it in the month of January.
Yes. TCR maybe fix, maybe within a stipulated period. We will deposit the special messenger.
Appellants shall deposit the special messenger cost for the TCR.
Yes, sir.
Let this matter appear on 16/1/2025. 26.
26.
Can one?
Yes, can one is this is can one. Can two is order 41/27. That will be decided at the time.
Can one is disposed.
Yes, sir. Hello. Informal paper book may be also prepared by us.
Anyway, I shall pass it on the next day. Let the TCR comes.
Very well. Yes, 40 I'm appearing for the appellant in this matter. But there was a direction by from the Rashima to file a supplementary affidavit, but I have filed a supplementary affidavit to this effect,
This is what can one?
Yes,
Your application.
Yes, can. But this is injunction, Well, I have made some specific statement in respect to the disturbance which has been created by the tenant, after in spite of the order of injunction. Well, I am serving the my learned advocate, Yes, ma'am. And this is the supplementary affidavit.
So let us take instructions.
Wait, let it be filed,
Yes, learned advocates for the parties are present. The supplementary affidavit file be kept with the record. Copy be served.
Yes, already served, record,
Let this matter appear. Yes, how soon can you come ready?
2 weeks.
2 weeks.
2 weeks. After 2 weeks, this bench may not sit.
Lordship.
Okay, 8/1/2025. 8/12/2025.
Yes. Supplementary affidavit has been already served. Rashul, can you record that?
Supplementary affidavit is already served.
Yes. 8 December your lordship is fixing.
8th of December.
Yes.
Grateful, I'm appearing on behalf of the applicant, sir.
41.
Yes, madam. Excuse me. Can one is the application for condonation of delay. There is a delay of 107 days, my lord. The opposite
Service is complete upon the opposite parties.
with the endorsement not known. The copy has been served to the original address where the decree has been passed, my lord, in the same address. They are the heirs of the defendant, appellant. Judgment and decree, my lord, passed on 20th December 24, and
Yes,
this has been filed on 25th.
Can one?
Yes, my lord.
How many respondents are here?
3 respondents.
3 respondents.
Plaintiff respondents, 3.
3 respondents. So out of these 3, you have served how many? 2.
3, my lord.
All 3 you have served.
Yes.
But with regard to which respondent it has returned?
All of them, because my lord, kindly come to the decree portion. There, my lord, the name has not been changed even after substitution. So the only address I could get is that.
No, you have sent the notice to the address available from the cause title of the lower court. That you have done.
Yes,
and
my
that is the cause title shown in the
yes, my lord.
This second appeal also.
Yes, my lord.
So that you have served, but it has come with the remark not known.
Yes, my lord. Grateful.
Yes, record an order. Learned advocates for the appellant's petitioner is present. The application under Section 5 of the Limitation Act, being Can 1 of 2025, is taken up for consideration. It is submitted by the learned advocate that the notice sent to the respondents has written in the address appearing in the cause title of the trial court has returned with the remark not known. Stop. In the facts and circumstances, so far the application under Section 5 of the Limitation Act is concerned, the service upon the respondents is dispensed with. The application is thus taken up for consideration. How many days delay?
107 days, my lord.
The delay of another thing, have you served the trial court advocate?
My lord, only the respondents have been served, my lord.
Okay. Which paragraph you have stated?
The reason of delay, my lord, is from paragraph 4, my lord.
Okay.
My lord.
Yes. They're considering the grounds of delay as
onwards 5
submitted by the appellants. This court is of the view that in the interest of justice, the delay should be condoned. Thus, the delay of
107 days.
107 days in filing this appeal is condoned. Okay, so the appellant to take further steps prior to moving the matter before the Honorable Division Bench with regard to the other applications.
Grateful.
Two, 43, 44.
Yes, any matter, both sides present? যাকে তাহলে ডেকে দিন আর কি।
45, 46, 47, 48, 49, 50, 51, 52, 53,
Okay, not today.
4, 50, 55 and 6, 57, 58, 59, 60, 61, 62 to 64. 65, 66, 67 and 8, 69, 70, 71, 72 and 3, 74, 75 and 6, 77, 78, 79, 80, 81, 82, 83, 84, 5, 6, 7, 89, 90, 1, 2, 3, 4, 5, 6, 7, 8, 9, 100, 101, 102, 103, 4, 5, 6.
এটা নিয়ে নেবে, ঠিক আছে? ঠিক আছে।